What up? I think we're off until next week because of my debate with Drew. That's on me. What up, Tomato? Oh, I'm good. How about yourself? What up, regular dude 112? Is that an IRI emote? Pretty based. Pretty based to you? Why is everybody triggered by this? We did it so you could see our beautiful mugs the whole time, and because of the arrangement of the fucking desk. Everyone's like triggered. I stared lovingly into his eyes when he got here, alright? So he got plenty of eye contact. You don't have to worry about him. But thank you, Kevinator, for your concern. Oh, it's a little cold. No, you're my boy. You go for chicken and waffles? No. I did give him a Kit Kat and some water, though, for the road. I know it's a hard road. What up, girlies? Holy crap, I used this like steam thing. And my god, it has helped my sinuses. Big Yoshi Big Snow. What up, folks? Oh wait, I have to do my recap first. What is that? We're about to get started, folks. We might have to make it an emo. I'll take a look though. Just give me one more moment, folks. Good night, Da Vinci Code. Welcome, everybody. Happy Tuesday. Hope you guys are doing well. We are back live after a a really incredible debate with Drew Pavlou. Now, some of you have some commentary on that debate, and we'll put up an edit of it some point this week, hopefully in the next day or so. Would really appreciate it if you guys support that edit. But I have some thoughts about it. The first I've already kind of previewed. The whole like facing each other discourse, I don't quite understand that. It was because of the setup so you could see our faces, and I think it would have been more weird if we like turned to face each other, and there's not like a good table set up to do that. So yeah, I did not dye my hair. I do not, and I did not. And I will not. Well, who knows? I think it would be quite difficult to dye my hair. It's quite dark. I need to like bleach it first, right? Is that what the people say? First, some thoughts on the debate with Drew. I told him that I wanted to first kind of chart out his political journey at the start of it by asking some questions and getting a sense of like, well, why the sudden shift? This guy used to be a Bernie bro. He became like a based lib interventionist, whatever type guy. And then eventually turned into Elon dick suck. And finally into this like conservative, tepid supporter of Trump. And so I just wanted to chart that out. And it was kind of difficult to wrangle him. I don't know if you guys got that impression a bit. It was a fun conversation, no doubt. But the first part, I'm just like, his mind moves a mile a minute. And so it's and sometimes I feel like he's not listening to me. And I got that sense a few times. And to his credit, I think he admitted it a few times as well. But there were some things that I extracted from some of his elaborations on himself, which are that he very much cares about his own health and security, which is fine, of course. I thought it was a really funny moment when I asked him, well, would you want the genocidal acts that happened in the past? Would you say that those like shouldn't have happened? He's like, I don't know if I want to go there because, you know, if I say that, then I never would have existed. I saw a comment or like a chatter said like, you would have existed. Your soul would have gone into a different body. But that in conjunction with his statements about why he politically was moving to where he is, having to do with his maintenance of his own life now because he feels threatened by Hassan Piker and communists who are going to attack him. I'm like, your morality is whatever made you exist and whatever continues to let you exist. Which at the end of the day, I mean, aren't we all somewhat like that? We all want to exist. We all love being. Can you even imagine what it is to not be? I can't. Even when I fall asleep, it's like I'm still being. Also, note for you leftists. All right, we have a conservative. Anti-ICE anything from protests to the riots should absolutely not infringe religious freedom. Because you people assume those who change political ideology are just doing so for money and not from the idea we have a mind of our own and think for ourselves. Also, note for your leftists, over 70% of ICE agents are Hispanic in origin. I don't know if you're like having a conversation with yourself, but I didn't try to say that it was for a grift. And in fact, I didn't ever imply it even in the conversation that I had with Drew. I'm taking him at good faith that it's not a grift. I wanted to see why his mind changed. And you're like, don't ask questions about that. If you ask questions about that, that means you're bad faith asking questions. How dare you ask questions about what? Like, okay. No, it's quite a remarkable, even he himself admits that it was a remarkable change, from a Bernie bro to a light Trump supporter and / also still liberal hawk typey person. Right? Like, he very much supports a lot of the liberal hawk positions. He's talking about Clinton. So it's quite from being a darling of the liberal left to now being like a light MAGA supporter. I think it's an interesting thing to talk about. But Devil Game says, no, This is based on your prior debate. I didn't see the Drew debate. I voted Barack Obama twice before voting Trump twice. What does that make a guy like me? The stream ain't about you, but it can be if you want to have a chat at some point. I don't know why you voted for Trump after voting for Barack Obama. But, what do you mean, you people? But if you want to call in at some point, Devil Gamers, the mic is yours, all right? We all love you. And we love that you're here. But no, I wanted to chart that out with my friend Drew. Am I going to get canceled for that? No, I mean, he was a nice guy behind the scenes. You got to be careful, though. As I mentioned with the Anna Kasparian moment, we had a very genuine moment at Word War Debate. Same with Rob. Like, very good moments interpersonally. You can't be charmed into withholding criticism. Same thing with Drew. And so I'd have no problem characterizing our dynamic as friendly. You know, I'm a friendly person. The Devil Games 666 responds, because the left lost their collective mind the moment Trump went down the escalator. Sometimes, do you guys ever feel that, like, MAGA supporters, and again, this is not to stereotype, all right? So don't get triggered. Do you ever feel like sometimes, like, MAGA supporters talk like supervillains? The moment I came with, like, a backstory, like they're monologuing about their backstory. It reminds me a little bit of the kid from Incredibles. Incrediboy! I was your biggest fan, and you turned me away. Ah, more like schizos. So did Trump. Syndrome. Oh, sorry. What did I say? Incrediboy was his original name. He became Syndrome. Okay. But on the actual substance, wait, so one thing I extracted from his distillation of why he did it was how it seems to be focused not so much on like ideas in a vacuum / ideas making contact with reality, but more about how people who hold ideas do or do not threaten his continued physical health and existence in time and space, which I think is refreshingly honest. Refreshingly honest. I know I'm referencing movies. It's a big no-no. Oh, my crystal clear is on a 3-stream streak. Third time, did always think you are pretty nice. Thank you. So that was one thing that was interesting that I extracted. The other one was another persistent theme, which I thought was borne out in a couple of examples. Namely, contradictory beliefs or values, it seems. Or at least on the face of it. I'll give you a couple of touchstones here. The first is on anti-authoritarianism with respect to China. Avi and I are having a discussion on Groypers. That's up next. That's like the part 2 of the conversation we started, but we don't know when we're able to do that. I wanted Avi to come be here during the actual discussion with Drew, but it was just like too last minute. Drew was too flaky. It was like right up into like that weekend. And I kid you not, now that we've said it live, I'm going to tell you, the dude messages me like a week before he's supposed to be in the United States. And he's like, so can you set up like a live event with tickets so like everyone can come? I'm like, hey, first of all, I don't know how many people are going to come for the Pisco show in New York City on like a random weekday at 6 o'clock. Second, no, it's impossible with a week notice. 3, it would cost like tens of thousands of dollars. 4, you don't seem like a person who seems that concerned about the assassins, the communist assassins who are trying to like go kill you. Also, I saw some people react to my conversation. This is another digression. Sorry, I'm getting scatterbrained. Where I said about Wick's X person versus the world, where I said D-tier celebrities, referring to myself. I'm obviously fucking joking. People like, I think from now on I have to preface every like sarcastic. I can't even do like witty banter without people losing their minds. Be like, oh my god, I should be treated like a celebrity. I guess I did say D-tier celebrity, but I don't want to be mistaken for being serial. No, I was joking, guys. I was joking. Today I have to talk to you about something that's deadly serious. Drew Pavlu debate. All right. Sorry. Where were we? Yeah, so contradictions. First, China, where he seems to recognize the horrible state of authoritarianism in China and other of these countries, which is the premise of his opposition. He also looks to other international cases where this has happened, in some communist regimes, of course, where that occurs. Missy says, I like your humor, but people who don't like you pretend not to get it. Yeah, sorry. I don't find myself, I'm not like a funny guy, all right? I'm not like this delusional person who thinks that like humor is my greatest strength. That's not my value add, okay? But sometimes I think people take me a little bit too seriously. You look like a guy who takes himself too seriously. We also took a selfie, and that's pretty funny. The dude is taller than I expected, but shorter than me. Where was I? Yes. So he picks these countries where they have very oppressive communist authoritarian regimes, but then doesn't seem to realize that all the people he glazes have some aspect of that sort of authoritarian impulse. Like Bukele, like what he proposed he wanted to do in Australia, which is like just round people up who have affiliations with extremists, obviously very bad, but like not necessarily on any particular charge or with any kind of like sufficient evidence of specific wrongdoing. And so doesn't that kind of feel like the bad stuff we don't want to turn into? What distinguishes us? And I think at bottom, what we've extracted, in addition to the save Drew Pavlu's life principle, which he's self-aware about and honest about, and, you know, good on him, is the pro-West position not from a position of like Western values, because that's not the distinguisher. It's Western society in virtue of its Westernness, in virtue of it being Western. So, of course, authoritarianism, in order to destroy other authoritarian governments that aren't Western, that's justified. So that was one which I thought was a little contradictory. And then also some of the race stuff, where he's like, of course, you know, I wouldn't want the voice. I don't support these race policies. And when we're talking about the voice, that was a proposed part of the constitution to Australia, or a proposed part of the law of Australia that would have given the native peoples of Australia a kind of ceremonial body, which would have some amount of powers, but not really anything affecting major legislation of any kind, really. You can read more about it. I'm just trying to give you the general impression. It's not like they had exclusive anything to like actually make laws by themselves or anything. It was more of a channeling body through which negotiations could happen, the position of the native representatives could be borne out, and again, that's all in this particular cultural context, and people can have differences of views on whether that's appropriate or not. But so he was very much against that, but kind of like in favor of some version of a racial policy when it comes to immigration. Kind of unclear. They do this kind of like, well, it's about culture, not about race, ethnicity thing, which a lot of people do. But when you start to ground it out, it becomes more ambiguous and vague. You know, what does it mean to be white? Well, I've always thought myself as white. And white people look different. Yeah, you look different than an Anglo, my friend. You look a little different. On the intervention stuff, I think they give the game away. They don't just not respect international law. They don't really respect U.S. law that much. And I haven't heard a good case that the intervention in Maduro, in my opinion, will have this wellspring of humanitarianism results out of it. So I think that was heard from the audience, that in this specific case, he doesn't care about the legality of it. And if you're watching, if all of you are watching, you of course shouldn't take the intervention in Venezuela in isolation. Though you could if you wanted to, but if you're actually going to propose to take a look at the policy, I think you're required to take a comprehensive look at what's happening in America. In that context, in America, I think proposing to give more authority to Trump and to give him a blank check when it comes to the war power, after he is deploying military in our cities currently and forever trying to claim this state of exception that of course Pavlov tries to put on me, which is not the case. I think you got to be crazy, especially when the benefits are so ill-defined and it's being run by the scum of the earth, Trump and his cronies. Already had a wellspring of humanitarian results. Many cartel members already fled the country en masse, but Pisco will ignore this. I mean, I don't know where that's been borne out. The cartel members have fled the country en masse in Venezuela. Source for that. And this is precisely one of the issues that Trump was approaching from the other perspective when it came to running for office. Namely, they're sending drug cartel people. They're sending their cartel people into like other countries and shit. Like, why is that better? And also, isn't the problem from the humanitarian perspective the authoritarian regime in Venezuela? By the way, right, the allegation as to Maduro is that he's a narco trafficker himself, and that really this Cartel de los Soles, alleged Cartel de los Soles, that cartel is basically an agent of the state of Venezuela. It's like a functionary of the state. And so I'm not understanding why we now are separating these cartel members, that the government isn't in lockstep with the cartel anymore when it's convenient for you. It's better to clear out for Venezuelans for the Ven's citizens. Duh. They were literally invited in back in the day. They were literally invited in back in the day. So they're going to go back to where, so why is that net good? We're not capturing them, right? You said, and even assuming they've left, which source for that? Actually, I'm going to Google it right now. Where are you getting this? Venezuelan cartel members leave country. Yeah, can you tell me where you're getting this? So we're going to stop with Grant Withers. Source for the Venezuelan cartel members have already left, have in result of the strike against Maduro, they've left. We want a source for that. And by the way, even if I grant it, doesn't make it justified, and that doesn't solve a lot of the contradictions that I pointed out already. It isn't all of them out yet. Well, we just want a source for anything, for one cartel member leaving. Let's start with that. Again, this doesn't resolve the contradictions I pointed out to, the about face, the lie that Trump cares about the people of Venezuela, etc., etc. But we'll wait for that source here from Grant Withers. Grant Withers says the cartel members have... Oh, let's look at the wording originally of what he said. Many cartel members already fled the country en masse. This action has already had a wellspring of humanitarian results. Many cartel members. So the claim is many. The claim is many cartel members. So just to be clear, we have the source right here. Grant Withers, many. Uh-oh. We're waiting. for Grant Withers. Where did this come from? This claim. He wants to join VC. I mean, you can. You're allowed. You're allowed to join. We love conservatives. Grok, generate footage of many cartel members leaving the U.S. Not the U.S. Venezuela is the claim. Not that they're leaving U.S. Venezuela. Presumably, if they're leaving U.S. and being accepted in Venezuela, maybe that's worse for Venezuela, right? Or if they're... So we'll get into Halligan. We have a lot of legal updates to talk about. Pisco thinks everyone keeps their news article sources in their back pocket. Give a while. I will drop in server if it takes a while to find. Do you remember what you read? Do you remember where you read it? Or are you searching this? Where did you see this? Can you describe where you saw it? And I'll let it go. I just want you to tell us what you saw that makes you think this. What do you recall seeing? Or is it just kind of like a vague, I saw it on Twitter thing? Boom, boom, boom. We can help you find it too. If you join VC, we can all look together. We can all help you. Friends helping friends find sources for Venezuela and many, many much. What is the plural of box? Boxing. And then we'll do our legal updates once we sort this out. Grok, find this. Grant, just tell us what you think you saw. And we'll move on. Just tell us like what you recall reading or seeing. It was a news article or something with Crystal and Saga or TYT. Well, one of those things is not like the other, in my opinion. And also something on either Crystal and Saga or TYT. Okay. All right. That'll do for now. Go find it though. Go find that shit. Your job ain't done. Okay. Final thoughts also on other stuff with the Drew situation. The Drew situation. Other thoughts I had. Oh, the Hassan comments. I had my new tanky audience that I've been cultivating. I had messages from people being, "You're misrepresenting Hassan," or Hassan never actually said this. And so this was the case with like one of the claims about settler baby or something else. It was that, and then also whether they should be targets or something. But I mean, we can look into that if you want. I was sent a clip at some point, so I just want to note for the record that my newly cultivated communist audience is taking issue with the characterization by Drew of Hassan Piker's positions. My name is Commander Shepard, and this is my favorite channel is it all. Okay. Let us, oh shit, breaking news. And it actually goes into our very first story of the day by Kyle Griffin. This is a guy. Now this is a guy. Virginia U.S. Attorney, alleged U.S. Attorney, we'll get into it, Lindsay Halligan, who sought indictments against Trump adversaries, is leaving her position. If you recall, Lindsay Halligan was the attorney who sought indictments against James Comey and New York Attorney General Letitia James. Okay? She had no prior prosecutorial experience at all. She was a disgusting freak of nature, a freak. And she will live with that shame for the rest of her life of being a freak. And part of the reason perhaps why she's left the position is because it was determined by no fewer, I think, than 2, possibly more, decisions that she was appointed unlawfully. Because Lindsay Halligan, the prosecutor with no prosecutorial experience, the freak, they won't work for a freak, would not have probably been confirmed even in this Senate. So corrupt, so malicious, so stupid is she. If you recall some of her actions, she failed to get an actual indictment against Comey. This was revealed when Comey's attorney started digging and looking into the grand jury proceedings. And when they started digging, they noticed, these times don't really make sense. That you spoke with the grand jury foreperson who said they didn't sign off on part of the indictment, but they did on another. But on the thing that they returned, it just said no bill, no indictment on anything. And then you just kind of like made a new one on the spot, or you crossed something out, which wouldn't have given you enough time to formally read the. So they started digging around. They're like, oh, this is corrupt. Oh, you were doing this last minute. You know when you have like the science fair tomorrow? By the way, I hope none of you, do any of you have homework that's past due? Do you have any college students or high school students in the audience that have homework tomorrow? Because if so, I'm going to have to ask that you do your homework. But imagine that you have homework and it needs to be done by like the closing of the statute of limitations of a crime. And if you don't do your homework, the president's going to be really, really mad at you, the president of the United States. Okay? Well, that's kind of what Lindsay Halligan's position was that was discovered in this further proceeding and the various different motions to dismiss that James Comey filed. And we were discovering mucho malfeasance. Mucho malfeasance. You're going to have stress dreams about not doing your homework. Does that count? It does. It does count. So she just kind of phoned it in, and really disqualifying Lindsay Halligan was more of like a nice gesture. Because my guess is, I'm kind of being a little bit facetious here. The court is obligated, obviously, to enforce the law, and they had an obligation to do it. But it probably was not the worst thing that Lindsay Halligan could have expected. Because I think if they had dug around some more, they would have found even greater amounts of malfeasance, more discovery, more embarrassing shit related to the prosecutions of Trump's political opponents. Oh, Halligan has released a statement. I'm sure this will be very professional, very chill. I haven't read it yet, so I'm sure this is going to be very chill. All right. So, guys, my prediction is this will be a chill statement. I haven't looked at it at all. All right. So that's just my prediction. I just want you to know the prediction. This is the prediction. And we'll read this together. All right. We're literally reading this. This is for the first time. I served the full 120-day appointment authorized by the Attorney General of the United States. That appointment concluded on March 20th, 2026. You have the dates wrong, bitch. On November 24th, 2025, Judge Curie ruled that my appointment was invalid and held that following Eric Siebert's departure, the authority to appoint an interim U.S. attorney for the Eastern District of Virginia rested with the district court and only the district court. From that point forward, the district court repeatedly treated my appointment as disqualifying, because it was, citing Judge Curie's ruling as controlling authority. My name was struck from filings. Disciplinary proceedings were threatened. I was subjected to baseless accusations of lying to tribunal. You did. And making false or misleading statements. You did. I was ordered to respond to sua sponte orders and to personally sign filings explaining why my name appeared on pleadings, diverting time and resources from public safety responsibility. Give me a break, you piece of shit. You were not appointed because of the need to protect the public. You were appointed to pursue the political enemies of Donald Trump. That's it. If the administration cared about the public safety of the American people, they wouldn't have appointed someone with no prosecutorial experience, who has never worked in the Department of Justice. But you were picked solely on the basis of your slavish devotion to Donald Trump. That's it. That's the only reason you were chosen. And so diverting time and resources from public safety responsibilities, I'm going to call that as characterizing your entire appointment and your decision to file charges against the political enemies of your master. Miss Halligan, because you have a master. Your master is Donald Trump. And the reason why you were called to explain your signings is because you represented to be something that you were not. You were signing those filings, U.S. Attorney Lindsay Halligan. But of course, you're not U.S. Attorney Lindsay Halligan, and you never were U.S. Attorney Lindsay Halligan. Legally or otherwise, you were a bounty hunter sent by Trump and a tool to corrupt this country. And all of your aspersions at the judiciary are copium to explain your failures. Because even as a tool of the administration, which you were and which you are, you failed to be minimally competent to at least do the corrupt prosecutions well. There were no fewer than 4 or 5 incredibly strong bases to dismiss the indictments against Comey that you attempted to bring. Whether that case will ever see the light of day now, it shouldn't for many reasons, but especially because of your incompetence, that remains to be seen. AUSAs were told in open court that I should resign. Well, it's not about you resigning. How do you resign from a position that you don't hold? Right? That would seem kind of weird, right? So let me give you an example, guys. Imagine that you were like, imagine that you were like a Reddit mod. All right. This is the only reason I bring up this example is because it's on people's minds. And then you're like, the people are telling me I should resign my position from Reddit. They're like, what? Wait, but you don't work for Reddit. Yeah, Lindsay Halligan, you don't have a position in the Department of Justice as a U.S. attorney. It's not about you resigning. It's about you not lying to the court by pretending to be something that you're not. Despite this treatment, as though she's maltreated, what do you think the court should have done? Halligan? Pretended that you were who you were, even though they swore an oath to uphold the Constitution and all the laws made pursuant to it? The district court failed to take the one action its own interpretation of the statute and Judge Curry's ruling required, appointing a new U.S. attorney. Well, it's a little tough when you have some dumb, I don't even want to go there, some 2 IQ Neanderthal in heels pretending to be the U.S. attorney. It's a little bit weird, odd, and perhaps complicated to take that necessary step when we have you pretending, gallivanting in the offices of the Department of Justice as though you were a member of the department and a U.S. attorney. Disgusting. You're an officer of the court. Show respect to this woman who corrupted our country. Never. No. What do you mean respect this woman? Respect this woman who is trying to destroy the country? Imagine defending this, even from the position of corruption, which these people all support. Right? These people all support corruption. And she didn't even do it well. And you guys are like, yeah, respect her. She's doing a good job. The court's remedy did not match its rhetoric. It treated me as though I had been removed from office, declaring my appointment unlawful because it was, and striking my name from filings because you're not that, while never taking the single step Judge Curie identified as the consequence of that conclusion, appointing a replacement. She's like, imagine that, right? She's still in the office. She's still holding herself out as such. And she's like, well, why didn't you just pick someone else? You need to clear out, Halligan. In short, the court took no action to fill the vacancy it said already existed. The result was a vacuum. The executive branch was told it lacked appointment authority, and the judiciary declined to exercise the authority it claimed was exclusively its own. That contradiction is now on appeal. I see. I mean, is it? Because you just said the appointment's concluded. Right? So are you going to come back to pretend once more to be the thing you're not? Because I don't know if you checked the date, Miss Halligan. Maybe you're so incompetent that you don't own a fucking calendar. This is the ruling. It's pretty funny. Let me just do this. There we go. Order striking and barring the future use of title. So this is the court saying, hey, dumb fuck, stop using this title that doesn't belong to you. Citing an opinion that violated the Constitution, right? And the law. It violated both the statute regarding temporary vacancies and the appointment of like interims, and also the appointments clause of the Constitution. This is the Letitia James case as well. Right? Happened in Comey, happened in James. I conclude that the Attorney General's attempt to install Miss Halligan was invalid. She's been unlawfully serving in that role since she was invalidly appointed. All actions flowing from her defective appointment constituted unlawful exercises of executive power. So you can't do this. Halligan's response, where she was joined by the AG and the deputy AG, two other freakazoids, contains a level of vitriol more appropriate for a cable news talk show and falls far beneath the level of advocacy expected from litigants in this court, particularly the Department of Justice. This is a Trump appointed judge, saying, hey, the chief law enforcement officer and her number one deputy, as well as you, Miss Freakazoid Halligan, your level of vitriol in your appointments in your filings are better fit for news debates as opposed to litigation before the district. The court will not engage in a similar tit for tat. By the way, this is like all judge code for you guys fucked up, and I'm admonishing you. Don't take this kind of like more nice and polite language as like, oh, whatever. This is harsh for a judge. The court will not engage in a similar tit for tat and will instead analyze the few points that Ms. Halligan offers to justify her continued identification of her position as U.S. Attorney before the court. Ultimately, the court concludes for the reasons that follow that Ms. Halligan's continued identification of herself as the U.S. Attorney for the district ignores a binding court order and may not continue. Otherwise, Ms. Halligan and anyone who joins her on a pleading containing the improper moniker subjects themselves to potential disciplinary action in this court pursuant to the local rules. Put this on the long-running list of times the administration has openly defied, flagrantly ignored court orders, right? There's a court order saying, you're not the you're not the U.S. Attorney. And they just ignore it and keep as though that order, which is binding, did not apply to them. in her opinions, right, this is related to Comey and James, not James Comey. James Comey and Letitia James. I know that's confusing for some of you Trump people. Set forth a procedural history leading up to her decision. The court recounts only that which is necessary, which is that on January 20th, the Biden-appointed U.S. attorney resigned. Then we have this interim appointment, Siebert. Remember why Siebert was let go? Or I think he resigned. Then Trump, as he often does, be like, he was fired. Why did Eric Siebert, a Trump pick for interim attorney general, why did he leave? Why was he forced out? It's because he refused to corruptly indict Comey. That's why Siebert was forced out. These scum fucks. God, these people are disgusting. Siebert's 120-day interim appointment was set to expire on May 21st, but the judges did pick someone, right? The judges picked Siebert. And on September, after being pressured, right, this is like 6 days before the statute of limitations expires on the Comey bullshit charges, trumped up charges, fake indictment by scum. Trump is pressuring. Imagine if Biden did this. Imagine if we have Biden directing his department like this. You can't even say it, because to say that double standard out loud, it would cause you to be so angry that, and I don't want to do that because I can't finish that thought, but I just want you to like for a moment, take one little toe into the alternative universe. If Biden had done this, absolute insanity. And then we have this late alleged indictment, right? Alleged indictment. No actual indictment. Thank you, Vasraka, for the gifted memberships. Appreciate you. Comey moves to dismiss on many grounds, one of which is the appointment qualification or disqualification of the person pretending to be the U.S. attorney in the Eastern District of Virginia, as noted by Judge Curry in this case. Chief Judge Albert Diaz. Oh, right. They had someone from a different district sit in to decide the motion. Someone other than someone within the district. Got it. And so Curry was the duly overseeing judge. It didn't transfer the Comey case to Curry just to resolve the issue of Halligan's appointment. Curry issued the opinion. She was invalidly put in there. And although the president has nominated her for the position, the U.S. Senate has not acted on the nomination. Notably, even if Ms. Halligan was validly appointed by AG on September 22nd, 2025, that appointment would expire today. Right? So even if it were the case that she was validly put under the interim position, as noted by Halligan herself, it would only last until today. Despite Curry's rulings, Ms. Halligan has continued to identify herself as the U.S. attorney for the district in pleadings, including on the indictment and other pleadings in the case. Some of my colleagues have orally struck the invalid moniker, right? Not the only judge, while others have made notations that indicate their rejection of her identification as U.S. attorney. Crazy, right? Insane. I elected to give Ms. Halligan an opportunity to explain her position. And after reviewing it, I find her position to be unavailing. Halligan, essentially, thank you so much. Not going to lie, if I need someone to prove my essay, Pisco would probably be the first guy. Oh, thank you. Appreciate you. Thank you for Super Chat. Halligan essentially offers the following arguments for her continued identification as U.S. Attorney. She initially asserts that Judge Curry's ruling did not prevent her from identifying herself as U.S. Attorney, and that her holding does not constitute binding precedent. Imagine that. Like, and they always do this. These Trump people always do this. You did order and make a decision that I wasn't validly appointed, but you didn't order me not to call myself that thing. Really? Is that your argument now? That the order regarding being the U.S. Attorney invalidly, that order doesn't mean you don't have an obligation not to represent yourself in open court when, you're under the court's rules not to lie, and as well as your own ethical obligations not to lie? That somehow you're not under an obligation to be candid and forthcoming about what position you hold to the court? Next, Halligan asserts that the party presentation rule somehow prevents the court from sua sponte, inquiring as to whether Miss Halligan accurately identifies herself as such. Relatedly, Halligan also complains about the court's reference to the ethical implications of her false assertions. Let's see the footnote, usually spicy things. Halligan also asserts that former special counsel Jack Smith continued to use his title after his appointment was found to be invalid. Miss Halligan's reference to the former special counsel Smith did not merit serious consideration, given the inapposite context. Miss Halligan appears to share the current administration's unhealthy obsession with the former special counsel. Jesus Christ. But Mr. Smith's decision to leave his intact his signature block following a court order asserting the illegality of his appointment lacks legal significance here. As such, the court will not be diverted from addressing the issues related to the lawfulness of Miss Halligan's assertions. As at least one reference point, the special counsel statute, right, doesn't involve the interim appointment process, right? Number one. Two, there's no appointments clause problem, since a special counsel is under U.S. Attorney /AG. And then third, Judge fucking, who's this woman? I used to know her name. We used to curse her name every day. Out of the Southern District of Florida, Judge Cannon, Eileen Cannon, her decision was insane. As well as in a separate district from the one in, Jack Smith's other case. So at least three differences there. But very nice. Always look in the footnotes for the most spicy judicial little smackdowns. First, Judge Curry conclusively determined that Halligan's appointment was invalid. She asserts that Judge Curry's order finding Miss Halligan's appointment unlawful has no effect on her ability to refer herself as the U.S. Attorney. In support, Halligan highlights that Curry did not expressly enjoin her from continuing to perform the functions of the office. In addition, Miss Halligan submits that Judge Curry did not issue a declaratory judgment. They're like, you said I couldn't touch you. Not that I couldn't be this close to you. According to Ms. Halligan, under the Supreme Court's recent decision in Trump v. Casa, the district court lacks the authority to bind the U.S. in cases involving third parties. I don't even understand the logic of this. So the case is U.S. v. Comey. Oh, they're saying, how can you under Trump versus Casa? What do we need to do? A class action? How do you stop me? Look at this theory of executive power here by Trump. Trump is basically saying the court can only rule my appointment invalid with respect to a single case, and it has no other value. That the court's determination that she was invalidly appointed, that only applies to the specific cases. So stupid. Grant Withers, did you find that? What are you doing? You still have to do your job. Why have you stopped looking, Grant Withers? You're eating? What? And you can't look for the fucking article while you eat? But you can type in my fucking chat. You're supposed to find the article of many cartel members leaving Venezuela after the attack on Maduro. That's what you were supposed to do. Yeah, but you're typing. I know, but no, you're typing. You could be searching. That's what you need to do. Or admit, you know what? I can't really produce this. Yeah, true, Eddie. Yet in levying this argument, Halligan fails to acknowledge the unique context of Judge Curie's order, which fatally undermines her argument. As set forth above, the Fourth Circuit issued an order designated and assigning Judge Curie to hear and determine pending and future motions concerning the appointment, qualification, or disqualification of the U.S. Attorney or U.S. Attorney's Office in the matter of U.S. Comey and all other cases involving similar challenges, citing the order. The court notes that Halligan appeared as counsel of record in both Comey and James. As such, Halligan is well aware of this order. Critically, Chief Judge Diaz assigned Curie to resolve not a particular motion in a particular case, but a specific issue, the validity of Miss Halligan's appointment. With words that could not have been clearer, Chief Judge Diaz directed Judge Curie to resolve any and all motions pending and future concerning the appointment of the United States Attorney both in the Comey case and other cases involving similar challenges. In so doing, Chief Judge Diaz, in his capacity as Chief Judge of the Fourth Circuit, granted Judge Curie the authority to resolve the issue of the legality of Miss Halligan's appointment on behalf of all judges regularly sitting in the Eastern District of Virginia. He did so for the purpose of maintaining public confidence in the impartial administration of justice and in recognition for the potential of a perception of conflicts of interest among the judges sitting in the Eastern District of Virginia, who regularly adjudicate matters litigated before the U.S. Attorney's Office, by the U.S. Attorney's Office. As such, Judge Curie was appointed with the express mandate to speak for all judges in this district on the issue. Judge Curie's voice constitutes the voice of all the district judges of this court, and her determination of this issue necessarily extends to all matters in our court. The unique procedural posture involved in her expansive authority on behalf of all judges disposes of Halligan's arguments that Judge Curie did not issue a declaratory judgment, and even if she had, nothing in the Declaratory Judgment Act authorizes a district judge to issue advisory declarations. Whether or not Chief Judge Curie's order constituted declarative judgment is irrelevant here, where Chief Judge Diaz granted her the authority to rule on the validity on behalf of all judges and where the resulting order constitutes the law of the district with respect to all similar challenges. Rather stunningly, Ms. Halligan fails to even mention the order, let alone discuss its impact. In short, Halligan has not only ignored the rulings, she also turned a blind eye to an order from the Chief Judge of the Fourth Circuit. The court finds it inconceivable that the DOJ, which holds a duty to faithfully execute the laws of the United States, even those which it may have disagreement, would repeatedly ignore court orders while simultaneously prosecuting citizens for breaking the law. In the wise words of Judge J. Harvey Wilkinson III of the Court of Appeals for the Fourth Circuit, we yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos in Abrego Garcia versus Nome from the Fourth Circuit. Do you guys remember that decision of Judge Wilkinson? This was, I think, a Reagan-appointed judge. And this was when Trump was refusing to follow the Supreme Court and their order. Remember this? And these are dark days, my guys. Dark, dark days. And I think that it's a bit naive to believe that our brethren in the executive branch perceive the rule of law as vital. Naive, yep. Ms. Halligan's suggestion that Judge Curie's order, speaking as it does for all judges in this district, fails to affect how she may identify herself in court filings before this court rings hollow. Halligan asserts that since Judge Curie's finding concerning her unlawful appointment only served as the rationale for her dismissal of these indictments rather than the operative judgment, it fails to possess any legal effect. Ms. Halligan's argument fundamentally misunderstands the legal significance of such rationales. It usually is a judge's decision's reasoning, its ratio descendendi, my old Latin teacher would kill me, that allows it to have life in effect. See Ramos versus Louisiana. I think this is a case involving juries. I think that's right. And as the Fourth Circuit reiterated just recently, a decision's rationale binds us, even if immaterial facts differ. Ms. Halligan does not contest that Curry's holding concerning her unlawful appointment was necessary to the outcome. So it's not dicta, right? What they're trying to say is this is not dicta. The rationale here. The raison d'etre. As such, the distinction that Ms. Halligan seeks to draw between her ruling and the ratio descendendi. Oh, decendendi. Yeah, I think you're right. I think these are hard C's. Decidendi. Underpinning them lacks legal significance and fails to undermine the binding nature of Judge Curry's determination. Ms. Halligan's arguments based on CASA are similarly inapposite. Halligan quotes CASA for the proposition that neither declaratory nor injunctive relief applies beyond the parties. But that statement concerns the enforcement of contested statutes or ordinances, neither of which stands at issue here. More importantly, CASA addressed the specific question of the legality of nationwide or universal injunctions, whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy, which the court correctly termed an expansive remedy. No such injunction was ordered here, as Ms. Halligan readily points out, nor does this court concern itself with representations made by Halligan in other courts around the country. The court's concerns about Ms. Halligan's representation do not implicate the specific concerns that the CASA court set out to address, and more importantly, do not reach beyond this court, let alone across the nation. Rather, the court simply applies the legal precedent promulgated by Judge Curry's order, which disposes of the validity of Ms. Halligan's appointment for all matters in which her unlawful appointment became an issue in this district, to include the specific indictments in the case at hand. Significantly, while CASA sought to address what it termed the problem of district courts asserting the power to prohibit enforcement of a law or policy against anyone, it did not concern itself with open defiance of court orders. Open defiance, right, of court orders. This is what the court here is characterizing what Halligan and Trump are doing. Open defiance. Quite to the contrary, as the CASA court affirmed, no one disputes that the executive has a duty to follow the law. That includes Ms. Halligan. In sum, Judge Curry, speaking for all districts and district judges in the district, found Ms. Halligan's appointment as interim U.S. attorney unlawful and issued 2 orders dismissing indictments, both which were premised directly on that rationale. Those orders, though currently on appeal, have not been overturned or stayed, and thus constitute the law of this district. Having been found by this court to be unlawfully appointed, Ms. Halligan lacks lawful authority to represent herself as a U.S. attorney before this court. Importantly, in the face of Judge Curry's rulings, Ms. Halligan had numerous legal options that could have potentially allowed her to validly identify herself as the U.S. attorney while the Senate considers her nomination. First, she could have sought a stay from Judge Curry, Judge Nakemoff, or Judge Walker, or the Fourth Circuit. Second, she could have petitioned the district court of this court to appoint her, pursuant to 28 U.S.C. section 546 sub D. This is the interim, right, giving it to the courts. As the court did at the request of the Department of Justice for Mr. Siebert. Difference is Siebert was competent. Halligan is not. Alternatively, she could have filed a motion with the chief judge, allowing her to continue to use the moniker pending appeal, or filed individual motions seeking permission to use the title before each of the district judges of this court as her office filed new cases, either by indictment or information. Halligan chose none of the legal avenues. She simply elected to ignore valid orders at the direction of the chief judge of the Fourth Circuit. This court cannot tolerate such obstinance, because doing so would undermine the very essence of the rule of law. If the court were to allow Ms. Halligan and the Department of Justice to pick and choose which orders that they will follow, the same would have to be true for other litigants, and our system of justice would crumble. Simply flouting a judicial order because of disagreement of interpretation and acting like that order does not exist is not an option. She could do that, or she could read what a fucking, this guy's a troll. Hey, if the next thing, Grant, I'm not gonna address any of your other comments. Feel free to keep putting shit in the chat, whatever. But I'm not gonna address anything that isn't a citation to your claim or you admitting that your claim is not substantiated. So one of those two options for you. but I'm going to ignore you going forward until those are provided. Ms. Halligan next complains that the court acted on its own initiative. So this is the question about whether or not the court was right to do sua sponte. Here again, Halligan's complaint lacks merit. It remains emphatically within the power of every judge to preserve the integrity of the judicial process. As Justice Scalia eloquently explained, Article 3 courts as an independent and co-equal branch of government derived from the Constitution itself. Once they have been created and their jurisdiction established, the authority to do what courts have traditionally done in order to accomplish their assigned tasks. They derive that authority from the Constitution. Some elements of that inherent authority are so essential to the judicial power that they are indefeasible, among which is a court's ability to enter orders protecting the integrity of its own proceedings. So courts have the authority to make sure that their basic functions are allowed to continue inherently. Judges also shoulder an unequivocal duty to act in the face of threats to the integrity stemming from the actions of lawyers practicing before them. So, inherent authority to enforce like the rules of conduct, etc. Thus, the court's identification of potential ethics violations by Ms. Halligan, who appeared before this court as an attorney of record, and its provision of notice to Ms. Halligan regarding those concerns falls squarely within its Article 3 authority, the separation of powers arguments notwithstanding. Indeed, for example, this court enforces ethical rules against a notorious criminal defense attorney and former Commonwealth's attorney from Richmond, Joseph Morrissey, who defied the court's local rules and the court's orders. In doing so, the court found him in contempt, sentenced him to 6 months imprisonment to include a violation of the terms of his probation, and disbarred him. The Fourth Circuit affirmed the court's jurisdiction to consider the disbarment and its decision to order disbarment. In so doing, it affirmed the panel's reiteration that federal courts have inherent power to control the admission of attorneys to their bars and discipline attorneys who appear before them. As Mr. Morrissey's matter powerfully demonstrates, there exists no reason why this court should perform its critical function of maintaining the integrity of judicial proceedings with any less vigor when the miscreant serves in federal or state government, as Ms. Halligan currently does, and as Ms. Morrissey once did. God damn. Let him cook. Yeah, that's right. He called you a miscreant. I say freakazoid. And this judge says miscreant. And to be clear, Ms. Halligan's employment with the DOJ offers her no safe haven, regardless of her state bar membership. The court's ability to address potential ethics violations by Ms. Halligan or other government attorneys is expressly set forth in the local rules. Stated more simply, all attorneys who appear in this court, including all government attorneys, are bound to abide the Virginia rules of professional conduct, and if they fail to do so, the court may refer them for disciplinary action. Finally, Halligan argues that the court lacked the authority to enter its Jan 6 order and lacks the power to strike the errant portion of her signature block without a request to that effect by a defendant. So the defendant didn't request that. It was sua sponte. While true that a defense motion would have provided a valid vehicle, none of these neuter the court's ability to do so on its own authority. As is well established due to the very nature of the court as an institution, it must and does have an inherent power to impose order, respect, decorum, silence, and compliance. Under that power, a court may issue orders, punish for contempt, etc., etc., etc. The Supreme Court has reminded lower federal courts that these inherent powers must be exercised with restraint. The court's authority to issue an order in this matter and to strike her unlawful assertion falls comfortably within its inherent power to impose respect and compliance with lawful mandates. The insistence on including U.S. Attorney in her signature block exhibits disrespect not just for the court, but flouts the rule of law more broadly. It also self-evidently manifests noncompliance with Judge Curie's order. True. The court's remedy of striking the words United States Attorney from her signature block constitutes a minimally invasive approach to reestablish respect for and compliance with the law in an active case before the undersigned. It falls far short of other exercises of inherent judicial power, such as imposing sanctions or dismissing an indictment. Nor does it seek to relitigate the validity of the Halligan appointment. As such, the court's remedy constitutes a reasonable response to a specific problem. Finally, no express rule or statute contradicts the court's authority. For all these reasons, the court acted well within its inherent power. At the end of the day, Ms. Halligan's response asserts that she is free to act in an unlawful capacity because she disagrees that she does so unlawfully. But that's not how our legal system works. By having continued to exercise the position in which she was unconstitutionally appointed, including by signing the indictment in this case as U.S. Attorney, Halligan exercised power that she did not lawfully possess. In the words of Justice Gorsuch, since Ms. Halligan was unconstitutionally installed, she cannot wield executive power except as Article 2 provides. Attempts to do so are void. Consequently, this court must void her attempts to exercise power that she did not possess lawfully. Conclusion. Yeah, I saw that, Bimble. The Eastern District of Virginia has long enjoyed the service of experienced prosecutors with unquestioned integrity from both political parties serving as the U.S. Attorney. Despite coming from different political backgrounds and holding very different ideological views, they all shared an unwavering commitment to the rule of law, putting the interests of the citizens of the district before their own personal ambitions, as true public servants do. Unfortunately, it appears that this ethos has come to an end. A district judge acting at the direction of the chief judge of the Fourth Circuit has ruled on behalf of the district judges of this district that Ms. Halligan was invalidly appointed as U.S. Attorney. No matter all of her machinations, Ms. Halligan has no legal basis to represent to this court that she holds the position, and any such representation going forward can only be described as a false statement made in direct defiance of valid court orders. In short, this charade of Ms. Halligan, masquerading as the U.S. Attorney for this district in direct defiance of binding court orders, must come to an end. For all of these reasons, the court hereby strikes the word U.S. Attorney from the signature block on the indictment, as well as all other government filings in this case. The court further bars Ms. Halligan from representing herself as a U.S. Attorney in any pleading or otherwise before this court until such time as she may lawfully hold the office, either by Senate confirmation or by this court pursuant to the subsection entitling the courts to do so. That bar shall become effective at 12:01 a.m. on January 21st, in about less than 3 hours, but of course rendered moot until by, I guess, Halligan stepping down. For the avoidance of any doubt, this bar does not prevent Ms. Halligan from entering an appearance as special attorney, whatever that title might mean, right? Because the title of special attorney, special counsel, whatever, that's not the same as U.S. Attorney. And this is the kicker at the end. This is one of my favorite parts to read, and you guys should all follow. I think the name is Adam. He's a legal reporter. He does really good coverage. Adam Klasfeld. But he posted this image, and I thought it was pretty funny. The court recognizes that Ms. Halligan lacks the prosecutorial experience that has so long been the norm. Has been the norm for those nominated to the position of U.S. Attorney in this district. Consequently, and in light of her inexperience, the court grants Ms. Halligan the benefit of the doubt and refrains from referring her for further investigation and disciplinary action regarding her misrepresentations to the court at this time. And I just have to say, this shit is bullshit. How many chances can the Trump administration get with its constant lies, treating them like babies? The government is supposed to be held to like a higher standard than normal attorneys, practicing attorneys. It's supposed to be held to like a higher standard than criminal defendants, etc. But it seems at every opportunity, the courts, and we all know why, and I'll tell you why in a second, constantly just give the benefit of the doubt to Trump, and is like, oh, because you're a baby, because you're literally inexperienced, we're going to assume that you're like a baby. Kafka and Zip Zip, Ghanem and Gilmore show. Didn't you already do a Kafka episode? However, this memorandum order provides notice that should Ms. Halligan persist in ignoring Judge Curie's orders and this memorandum order in any matter before the undersigned, the court will initiate disciplinary proceedings against Ms. Halligan and any other signatory to an offending, pleading pursuant to the federal rules of disciplinary enforcement. Blah, blah, blah. Signed, Dave Novak. U.S. District Judge. And just to confirm, so I wasn't lying to you, Judge Novak was appointed by Trump on October 17th, 2019. Trump appointed district judge. So that's our first bit of legal news, which is that Halligan, as we knew, is a crook, is not actually a U.S. attorney, and is a joke. No experience. And because she's such a moron, in a department filled now, at least in the leadership positions, with morons, you're in league with that moron. What's that movie? I think it's called Burn After Reading. You're in a league of morons. The quote. It's probably going to strike me.
You're the guy from the gym.
I'm not here representing hard bodies.
Oh, yes. I know very well what you represent. You represent the idiocy of today.
I don't represent that either.
Oh, yeah. You're the guy at the gym when I ask about that moronic woman.
She's not a moron.
You're in league with that moronic woman. You're part of a league of morons.
No.
Malkovich, man. What an actor. What an actor. But that's Halligan for you. That's just a little taste. It's not nearly the important substantive thing I want to talk about today. Just a little bit of, twisting the knife in for Halligan, as though she watches that. But we're all watching what she's doing. We're all watching her bullshit. What did Drew Pavlo do? Oh my God, he visited Maduro's Brooklyn prison. What a clown. Okay. All right. How many of you guys have been seeing analysis regarding the protest at the church? Raise your hand if you've seen this. And perhaps you also saw another of the League of Morons threatening prosecution for these protesters at the, but more specifically as well, Don Lemon. You guys seen this? Heard about this? Apparently, according to some people, I don't know if it's true, the pastor here is like working hand in hand with the ICE. The ICE. And we don't like ICE, do we, folks? Not one bit. Not one bit do we like ICE. We think ICE needs to go. They need to go. So imagine being a member of the cloth and working hand in hand with an authoritarian overreach. Well, they did do it in some other countries, you know. These churches, sometimes they will make these deals. Not every church focuses on charity and good tidings. Not every church is like that church in Hunchback of Notre Dame. What's that church called? It's the most famous church, right? Isn't that like the most... How do I not know the name of it? Is it just called Notre Dame? The Church of Notre Dame? There was like a fire there, wasn't there? What's the church called? Sanctuary, please. A monster. What's it called? Whatever. Not every church gives sanctuary to the poor, huddled masses. It's called Notre Dame. But that's just the political context. All right, that's the political context. We don't like ICE very much. What I'm now going to provide to you is some more neutral legal analysis. So we're going to put aside the polemicist hat for a moment, and we're going to focus on the kind of claims being made. So you'll have to forgive me. I'm going to put aside my polemicist hat. I'm going to put aside my based patriot hat. I'm going to put them on the shelf right where I can see them. We're going to wave to them, and now we're going to go into the world of legal formalism. Just so you guys are armed with knowledge, because this is an issue of deadly seriousness. Okay. The question on the day is, did these protesters, or did Don Lemon, violate federal law? And what do we think about a potential prosecution under federal law of either the protesters or Don Lemon? Okay. I'm not going to be able to answer that question because I've been looking for a better factual accounting of what occurred. But I can tell you, at least start to approach some of the principles that would animate a potential answer to that question and the laws that are being invoked from a federal perspective. But a lot of this is going to turn on stuff that I don't know personally. I didn't spend that much time looking, maybe like 15 minutes. But maybe it gets out there and you guys can sort of fill in some of the gaps, okay? But these are the facts as I understand them. It's unclear to me whether or not this church is open access, that people generally are able to come and go. It's unclear to me how it started and how this protest was organized. And it's unclear, my knowledge is not set on who is who in this obviously organized protest and whether Don Lemon has a central role, et cetera, okay? And so we're going to now take the facts. There was a protest. The protesters interrupted a service, apparently, and were loud, and the church people there didn't want them there. That's at least at some point once they started making it known that they're protesting the church and they're interrupting the service. So let's start with what people are saying from a legal perspective, the administration, and certainly a lot of right-wing influencers who want there to be legal consequences for this action. They're suggesting violations of at least one or two federal laws. I'll tell you what those are in a second, but let's just first take another set of laws that might be applicable. Laws against trespass, potentially. Laws involving, certain state actions, okay? So we're not going to analyze those because in general, the federal government doesn't deal, unless there's a federal nexus, with trespass by itself. And by all accounts, this appears to be a privately owned church and not one where the normal sort of trespass laws would be expected to be enforced by the federal government, or where there's a hook on that score. Likewise, harassment statutes, things like that, other kind of normal ordinances and state laws against this kind of conduct as between private actors. So we're not going to deal with that right now. We're going to deal with the claimed federal causes of actions, violations of federal law. And we're going to go first with, let's start with the Ku Klux Klan Act. So this is actually a series of laws that were passed in the 1870s. I think there's the Enforcement Act of 1870, and then the Enforcement Act of 1871 is the Ku Klux Klan Act. And I don't have the tweet ready right now, but Assistant Attorney General Dillon, I think that's how you pronounce it, Harmeet Dillon, she has indicated that she's considering / investigating for prosecutions of either the FACE Act or the Ku Klux Klan Act, aka the Enforcement Act of 1871. And the Enforcement Act of 1871, the statutory citation might look a little bit familiar. Well, it starts and begins to look very familiar because it's next to a very famous statute. And I think it's easier to resolve. So we're going to start with the Ku Klux Klan Act, and then we'll go to the FACE Act. So let's start at the law. 42 U.S.C. 1985. This is the modern codification of the Ku Klux Klan Act. 42 U.S.C. 1985. Now, for those of you with any legal background, what does this statute look close to? What does this look close to? Aren't churches town squares? No. Churches are not considered traditional public fora. I don't think so. At least not these kinds of churches. Well, for those of you who have any legal background, let me just go back a couple. Boom. This looks very familiar, right? So 42 USC 1983, or like a Section 1983 lawsuit. This is a very well defined, very well litigated cause of action. There are probably hundreds, if not thousands, of these cases filed every year. Very famous. 42 USC 1983. And this is basically a way for you to sue the government, specifically of any state or territory, not the federal government. But you're allowed under, and this is what it provides for. Every person under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof. There's that term again, within the jurisdiction thereof. What does that mean? Political allegiance? Does this mean political allegiance, Ryan? Fucking idiot. Oh, we should watch at some point their Cope stream. To the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such an officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. So this allows for lawsuits against states and DC, right? The government of states are the DC for damages. And it's very famous. Everyone knows about this. You get me? But we're not talking about this statute. Because, of course, this provides a remedy against state governments, and it's civil suits, right? The title is called Civil Action for Deprivation of Rights. But I'm just noting this because one of the piece of legislation passed after the Civil War was to allow for these kinds of lawsuits and to allow specifically for damages against certain officers who deprive individuals of rights guaranteed under the Constitution. What has considerably less jurisprudence, or I should say case law, are these other two statutes, 1985 and 1986. And they apply potentially as to private individuals. And here's what they say in relevant part for our purposes. If two or more persons in any state or territory conspire or go in disguise on the highways or on the premises of another, right? Let's assume that a church is the premises of another, for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protection of the laws or of equal privileges and immunities under the laws. Okay, well, that seems interesting. Or for purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within such state or territory the equal protection of the laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, members of Congress, or to injure any citizen in person or properly on account of such support or advocacy in any case of conspiracy set forth in this action, if one or more persons engaged therein do or cause to be done any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured shall or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. So, well, does that apply? And I think probably not, and I'll tell you why. First, let's go to 86, 42 U.S.C. 1986. This action is kind of similar to 85, but it allows for negligence. This applies liability to people who know about this in advance and do nothing to help it. Okay? But you need to have a qualifying 1985 to get here, probably. And there's very, very little case law on this. The U.S. attorneys, marshals, and deputies, marshals, the U.S. magistrate judges, are authorized to institute prosecutions against all persons violating any of the provisions of Section 1990 of his title, et cetera, et cetera. And there might even be criminal penalties as well. But anyway, why do I think that the Ku Klux Klan Act probably doesn't apply to what's happened here? Even though there are parts of the Ku Klux Klan Act, the Enforcement Act of 1871, that apply to purely private conduct, including conspiracies against, rights, we have to see that in context of the case law. Okay, I think this is it. Yeah. So this is a Supreme Court decision called Carpenters v. Scott. And there was a previous decision, I forget the name, I think it was called Griffin, before this in 71. Yeah, Griffin v. Breckinridge, that said, okay, 1985 sub 3, which is what I just showed you, right? I just showed you 85 sub 3. It can apply to purely private actors. And so we had that going into it. And so there was someone who brought a lawsuit, or there was a case involving a 42 U.S. 1985 sub 3 lawsuit premised on the First Amendment. And if you remember, the religion clauses, the First Amendment is not just freedom of speech, it's also the freedom of religion. And the court here was confronted, well, can you have a 42 U.S.C. 1985 action under sub 3 for violations of the First Amendment with a purely private conspiracy? And the court, in the majority by Justice White, said no. And I'll bring you to the relevant part there. We do not disagree with the district court and the Court of Appeals that there was a conspiracy, an act done in furtherance thereof, and a resultant injury to persons and property. Contrary to the Court of Appeals, however, we conclude that an alleged conspiracy to infringe First Amendment rights is not a violation of 1985 sub 3 unless it is proved that the state is involved in the conspiracy or that the aim of the conspiracy is to influence the activity of the state. And what I'm about to show you they say is basically the right at issue here is as between a person and the government. Right? How does the First Amendment start? Congress shall. So the scope of the First Amendment, and frankly of a lot of other rights, is between the government and the person. And so there needs to be, what the court will say and what we'll read, there needs to be a connection between the private people and some state, some government action for this even to be in scope, right? In what sense can you be thought of to try to deprive someone of a right with private conduct if you don't have rights as against private people, at least not the First Amendment? You have it as with respect to the government. Different than, for example, the 13th Amendment, which does give you rights with respect to other private individuals, or the interstate travel right, which applies both to the government and to other people. I'm confused. The KKK, no, not that the KKK is a state actor, but that to allege particular violations or conspiracies against rights, there needs to be, for rights that have a government nexus built into it, such as the First Amendment, there needs to be likewise some amount of state involvement, either in the plan or in the conspiracy. Contrast it, so basically think of two buckets of rights and privileges. The buckets of rights and privileges which have as a nexus or as a precondition state action, and those that don't. And those that don't are things like the 13th Amendment and interstate travel, and those that do are things like the First Amendment, Equal Protection Clause. And so now read the court. We do not disagree with the district court and the court of appeals that there was a conspiracy, an act done in furtherance thereof, and a resultant injury to persons and property. Contrary to the court of appeals, however, we conclude that an alleged conspiracy to infringe First Amendment rights is not a violation unless it is proved that the state is involved in the conspiracy or that the aim of the conspiracy is to influence the activity of the state. We also disagree with the Court of Appeals' view that there was present here the kind of animus that 1985 sub 3 requires. The KKK Act cannot be enforced. No, it can be, right? It can be. That's what we proved with Griffith, right? Which they're going to, or Griffin. Is it Griffin or Griffith? Let's just make sure. Griffin. Griffin held that it can be against private parties. But that this, right, whatever the conspiracy is, with respect to a right, that the conspiracy needs to actually implicate the right in the scope of what the right is. Namely, a right that necessarily implicates the state. There needs to be some sort of state hook for private people conspiring with respect to that right. If someone wants to, we'll get to the FACE Act. We're not done. Chill. This is my neutral analysis. And when I do the FACE Act, again, I'm not going to come to a determination as to it because I don't think I have sufficient facts. So I'm spoiling it for you. But I'm trying to give you the law, okay? So if someone conspires like, oh, we need to go shut up Charlie Kirk, right? And they conspire to go do that. That is a conspiracy for criminal action. It definitely is a conspiracy to stop him from talking. But how the court is going to construe that is it's not a First Amendment right conspiracy, properly understood. Because the First Amendment is only ever implicated, not when people are shut up because of what they say, but when the government shuts you up for what you say. Okay? So when you conspire to shut people up or to stop them from religiously doing whatever, you're not conspiring to take away their rights. You're conspiring perhaps to do other stuff, criminal. But the right only exists with respect to the government, that specific right. And so unless you're trying to get the government to do something or the government is in on it and maybe using you, there is no way in which your right is implicated. It's private person as against private person. And let the court explain a little bit more. The Equal Protection Clause of the 14th Amendment prohibits any state from denying any person the equal protection of the laws. The First Amendment, which by virtue of the Due Process Clause of the 14th Amendment, this is what's called incorporation. That's why there can be violations of the First Amendment against states at all, is because the Fourth Amendment Due Process Clause incorporates the First Amendment, which says Congress, now applies to state governments and their officials, prohibiting either Congress or a state from making any law abridging the freedom of speech. We have, and remember, right? Any law respecting an establishment of religion or prohibiting the free exercise thereof, that's what's omitted here, but it would also be included. Had 1985 sub 3, in so many words, prohibited conspiracies to deprive any person of the equal protection of the laws guaranteed by the 14th Amendment or of freedom of speech guaranteed by the First Amendment, it would be untenable to contend that either of those provisions could be violated by a conspiracy that did not somehow involve or affect a state, right? And the reason of that is clear, because your rights, at least this right, extend to governments. So that's why I say it's untenable. You're not conspiring to deprive me of my rights unless you're conspiring to do something which implicates this relationship between government and individual in the exercise of a right. Quote, "It is a commonplace that rights under the Equal Protection Clause itself arise only where there has been involvement of the state or of one acting under the color of its authority. The Equal Protection Clause does not add anything to the rights which one citizen has under the Constitution against another. As Mr. Justice Douglas more recently put it, the 14th Amendment protects the individuals against state action, not against wrongs done by individuals. This has been the view of the court from the beginning. It remains the court's view today. This opinion for the court by Justice Fortas in the companion case characterized the 14th Amendment rights in the same way. As we have consistently held, the 14th Amendment protects the individuals against state action, not against wrongs done by individuals. In this respect, the Court of Appeals for the Seventh Circuit was thus correct in holding that a conspiracy to violate First Amendment rights is not made out without proof of state involvement." And then they distinguish this case Griffin, because of course, this case Griffin that I mentioned at the beginning stands for the proposition that you're able to have conspiracies of just private people under 1985 sub 3. Griffin versus Breckinridge is not to the contrary. There we held that 1985 sub 3 reaches purely private conspiracies, and as so interpreted was not invalid on its face or as there applied. We recognize that the language of the section referring to deprivations of equal protection or of equal privileges and immunities resemble the language in the prohibitions of the 14th Amendment, and that if section 1985 sub 3 was so understood, it would be difficult to conceive of a violation of the statute that did not involve the state in some respect. But we observe that the section does not expressly refer to the 14th Amendment, and that there is nothing inherent in the language used in 1985 sub 3 that requires the action working the deprivation to come from the state. This was a correct reading of the language of the act, so they're not stepping away from Griffin. The section is not limited by the constraints of the 14th Amendment. The broader scope of 1985 sub 3 became even more apparent when we explained that the conspiracy at issue was actionable because it was aimed at depriving the plaintiffs of rights protected by the 13th Amendment and the right to travel guaranteed by the federal Constitution. Section 1985 sub 3 constitutionally can and does protect those rights from interference by purely private conspiracies. What's the difference? The 13th Amendment applies to private citizens against each other as well, and the right to travel does too. Griffin did not hold that even when the alleged conspiracy is aimed at a right that is by definition a right only against state interference, the plaintiff in a section 1985 sub 3 suit nevertheless need not prove that the conspiracy contemplated state involvement of some sort. The complaint in Griffin alleged, among other things, the deprivation of First Amendment rights, but we did not sustain the action on the basis of that allegation and paid it scant attention. Instead, we upheld the application to private conspiracies aimed at interfering with rights constitutionally protected against private as well as official encroachment. Neither is respondent's position helped by the assertion that even if the 14th Amendment does not provide authority to prescribe exclusively private conspiracies, precisely the same conduct could be prescribed by the Commerce Clause. That is no doubt the case. So this is now talking about the legislative authority, from where legislative authority derives. That is no doubt the case, but Section 1985 sub 3 is not such a provision, since it provides no substantive rights itself to the class conspired against. The rights, privileges, and immunities that 1985 sub 3 vindicates must be found elsewhere, and here, the right claimed to have been infringed has as its source in the First Amendment. Because the amendment restrains only official conduct, to make out their 1985 sub 3 case, it was necessary for respondents to prove that the state was somehow involved or affected by the conspiracy. The Court of Appeals accordingly erred in holding that 1985 sub 3 prohibits wholly private conspiracies to abridge the right of association guaranteed by the First Amendment. Because of that holding, the Court of Appeals found it unnecessary to determine whether it could be sustained as to the First Amendment. Conceivably, we could remand for consideration of these possibilities, or ourselves could consider them. We take neither course, for in our view, the Court of Appeals should also be reversed on the dispositive ground that 1985 sub 3's requirements that there must be some racial or perhaps otherwise class-based, invidiously discriminatory animus behind the conspirators' action was not satisfied in this case. So, what does this tell me, and what does that cause me to believe? Well, 1 + 1 = 2. If we have private conduct by private actors who walk into a church, and let's just assume that their goal was to prevent the free exercise of religion by these people, not clear that there's a conspiracy against rights. Why? Because there's no involvement as to the government. Now, maybe some individual could allege from the Department of Justice that they're trying to get Keith Ellison to do X, Y, or Z. But I don't think it's a particularly strong case. The Ku Klux Klan Act. Because Section 1983 also refers to a state, and even more exclusively to a state, I think that has issues as well. And then finally, the 1986 section is premised on a 1985 violation, and given that I think that there's a big threshold that needs to be covered, namely some sort of state action nexus, I think that that's what you would need to show. If you were a Trump supporter pissed off and you wanted to use the Ku Klux Klan Act against these people, I think you would need to show that there's a nexus with state action, because it would be premised on the very same right, or amendment, I should say, as at issue in this case, the First Amendment, freedom of free exercise of religion. Okay, so that's on the Ku Klux Klan thing. Sounds like a trespassing case. Again, that is not at issue here, since we're only analyzing the federal stuff, and I explained that before. And that would also be determinant on like whether or not this place was generally open to the public, etc., and when they asked them to leave and when they did. No, not stopping the service per se, but more like preventing people from entering. I can think of reasons of service can be interrupted, but not be a conspiracy or a crime. You just said stopping the service violates this act, right? No, I didn't say that. I said, assuming that this was done for the purpose of prohibiting the free exercise of religion, I think you would also need to show a state nexus for this act. We haven't analyzed the FACE Act yet. And I think that's pretty fair. I think it's pretty neutral. I've showed my work, and to me it makes sense. Most of our rights are against the government, not all. And these laws were passed at a time where like the KKK was working hand in hand with state governments as well, etc. Why wouldn't stopping a service do that? I mean, just listen to yourself, okay? Why wouldn't stopping a religious service, private people stopping a private service, why wouldn't that include state action? It doesn't include it by definition. There could be additional facts, right? Let's say Keith Ellison sent them. All right. Or let's say that they're doing this for the purpose of intimidating the Minnesota government or something. And you can show that. Maybe there you have a case. But I think you need to show a state action nexus. I don't think it's enough to say that a wholly private conspiracy, absent a state nexus, would make out a claim under 1985 sub 3. So like if I had intent to erect a barricade in front of the church doors to keep people from going into the church, could I be in violation? Again, not if, first of all, you don't even have a conspiracy. You need at least 2 people to have a conspiracy. So definitely no conspiracy there. But let's say you have 2 people. It's the same answer, right? You need to have some state nexus. Because the First Amendment doesn't protect your right to free exercise of your religion as against private people. It's as against the government. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Not individuals shall not infringe on that. Is state money involved? Maybe that would be a nexus if state money is involved somehow. But I think you need something real, something concrete. Yeah, I think it needs a state tie. But yeah. All right. So that's my analysis of the Ku Klux Klan Act. Let's go to the FACE Act. This was passed by Clinton in the 90s. And the idea was there was a rising series of violence against abortion providers and like reproductive healthcare centers. Like a lot, like hundreds of either deaths or injuries because of attacks. They were in the news all the time. And so they passed this law, which was intended to try to reduce this violence and have a federal enforcement nexus. But they included not just health services, but also religious worship. By the way, I believe Clinton also passed RFRA, right? Or is that Bush? Yeah. Clinton also passed RFRA, the Religious Freedom Restoration Act. So Clinton was part of this, I think, boring consensus that like we need extra protection of the churches. They're being attacked everywhere, which I don't necessarily agree with. I think that was like a pretext, and people were doing the satanic panic even before this, and then after that it was the games and all these like. So I think that it's a little bit hysterical, some of what occurred in the 90s, but Bill Clinton wanted to market himself as this big defender of religion as well. And so in addition to this protecting reproductive healthcare type stuff, it also directly is attempting to protect religious worship, etc. From my research, every single court to at least appellate court to ponder on the legality under the First Amendment and overall the constitutionality of this law has upheld it. And I'll tell you why. And what we'll need to make out. So first of all, here's a bunch of circuit court decisions. Second Circuit, Fifth Circuit, DC Circuit, like all from like the 90s and early 2000s, basically upholding it. And here's all of our sister circuits to address the First Amendment challenges to the FACE Act have upheld the act. And you see cert denied. So SCOTUS is denying reviewing the decisions of the lower federal appellate courts, indicating that usually it means like they don't have a big disagreement with them, given the amount of circuits that have come to the same conclusion. And so the notion that facially this law is unconstitutional, probably debunked, okay? And I'll tell you why. So first, let's read it. Whoever, by force or threat of force or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person because that person is or has been, or in order to intimidate such person or any other person or any class of persons from obtaining or providing reproductive health services, by force or threat of force or by physical obstruction, intentionally injures, intimidates, blah, 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 for religious freedom, or intentionally damages or destroys the property of a facility or attempts to do so because of reproductive or place of worship, shall be subject to penalties, and you have the crime, all right? And here, let's define physical obstruction. Means rendering impassable ingress to or egress from a facility that provides these different things, or rendering passage to or from such a facility or place of religious worship unreasonably difficult or hazardous. Okay? So now let's see the First Amendment analysis. We'll pick a case. I think I want to pick, let's pick this. Let's pick Brock. All right. This might have been one of the first ones. First thing to note is for the FACE Act, you need to show force, threat of force, or physical obstruction. Okay? Force, threat of force, or physical obstruction. Okay? I haven't seen any evidence of force, and I haven't seen any evidence of threat of force. Okay? Perhaps it exists. Perhaps it exists. I'm not saying it doesn't. But in the specific case, I'm just telling you, and again, threat of force isn't like I felt threatened. A threat of force is an intentional act. Wanting to put someone in fear. That's what a threat is. Not just someone feeling threatened. And I haven't seen evidence of that. So, I think the big question, unless there's some smoking gun of force or threat of force, he violated sub 1. Sub 1 is just about reproductive health services, okay? So don't get too excited, Juan Doe. Don't get excited. Just chill. All right? Sub 1 is not at issue. Why is sub 1 not at issue? Because it doesn't refer to religious freedom or churches. It refers to reproductive health services, and I have no reason to believe that this place was providing reproductive health services. Unless you think differently, okay? So we're just very calm right now. I want all the conservatives in the audience to be so calm. All right? Just be so calm. We're using facts and logic and not emotion. So don't get ahead of yourself. I also haven't seen intentional damage or destruction of property. That evidence might exist. Haven't seen it. So I'm only going to consider sub 2 for now. Guy says, sorry, I just took a huge ball rip. All right, so just chill, right? That should help you chill. Why do you think I'm conservative? I'm just assuming. I'm making an assumption just like you assumed sub 1, all right? Let's just be very chill about sub 2. Okay, you're not a conservative. You guys are so funny, man. You guys are funny. Let's look at sub 2, all right? This is like a math problem. You're all doing it together. We're all having fun. I'm going to repeat my point. I haven't seen evidence of force, and I haven't seen evidence of threat of force. And so I think the big question is going to be physical obstruction, because you need one of 3: force, threat of force, or physical obstruction. And then you need the dual intent. The dual intent with respect to the injury / intimidation. Okay? And so here are the kinds of things. Here are the kinds of things you might want to show for the intent prong. That these people don't want, they're upset with the religious teachings. That they don't like this, religious organization on the grounds of its theological teachings. If I were the government, I would try to focus on things with a greater connection to the religiosity of it, and any kind of statements by a proposed defendant with respect to the religion angle. Because the more it's tailored to, oh, you're doing this for First Amendment for speech, now it's like a kind of weird. Or if the defense said, listen, this was not at all about, we don't want them to stop doing their religious worship. We want them to stop working with ICE. Right? Right. The intention matters. This is so my BFF shotgun, great mind right now. Instantly you go to hypothetical. You go and say, this pastor's stealing money. Or you go in and say, this pastor, he's stopping all the altar boys from reporting their scandal, right? You get a bunch of your friends and go, he's a crook, right? He's stealing, he's not giving alms. So you need that intent with respect to the exercise in First Amendment religious freedom. Not just to attempt to injure, intimidate, or interfere, but also with respect to what, right? So that might be difficult facially because think about what the people would say. We don't have a problem with them exercising their freedom of religion. We support them exercising their freedom of religion. This has to do with corruption with ICE. And so we're not trying to stop them from doing X, Y, or Z. That's on the intent level. And I think that some of the cases for anti-abortion stuff are an opposite. Because in those cases, it's very clear that what they're trying to do is convince people or stop people from doing the service itself on the basis of its service. That said, you might also read this as, well, maybe you have some other purpose to interfere with some ICE thing, but you are trying to interfere with their rights as a way to get to your ultimate purpose. I'm not quite sure how the court will interpret that nuance. Someone who is using disruption to a service for purposes of some like greater aim, some greater motivation, who actually doesn't have a problem with the services as such, but just part of how they achieve it is through disrupting it. I'm not quite sure how the courts would understand that, but you could consider it an issue, right? Does the intent have to be so specific to the First Amendment motivation? Or can it be enough that you know you're going to interfere? How I would read it, again, rule of lenity, guy, more narrow about the purpose of the law, is this is really about anti-religious activity. This is really about anti-reproductive health service activity. It's not really so much about disruptions absent that, right? Like if you disrupt the abortion center because, I don't know, your ex-girlfriend works there, have you done this violation? I'm not sure. I'm not sure about that. But that's just how I would probably interpret it absent some other strong evidence to the contrary. I'm just telling you what my intuition is, what my inclination would be. Can I deprive? So this is not, right? This is not getting after them for a violation of for violating freedom of religion. Right? And this is super duper important. Read it. By force or threat of force or by physical obstruction, intentionally injures, intimidates, or interferes, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking to exercise their First Amendment right of religious freedom at a place of religious worship. So it's not that the person who does this is getting criminalized for violating their First Amendment rights. They're getting criminalized by using force, threat of force, or physically obstructing someone trying to use their rights, not for violating their rights directly. You understand? It's a nuance, but it matters. They're not saying, well, these people are violating their rights. It's saying these people are forcibly, through threats or through obstruction, physical obstruction, interfering, injuring people who are trying to use their rights. I think it's a coherent concept. Trying to exercise their First Amendment rights, I think people would understand the meaning of that to be engaging in First Amendment public activities on the basis of the particular activities that are in fact protected, right? I know that's a little wordy, but they're trying to do something that's protected. As to the government, yes. And so in trying to interfere that way, it's not itself a violation of those rights, but it is doing other things that someone who is trying to assert those freedoms or do actions which are protected by those freedoms. These are all great questions, by the way, because you're trying to, we just talked in the context of the Ku Klux Klan Act about how the right really is more tailored to the government. Then how can this exist? Well, it's because it's not criminalizing a rights deprivation. It's criminalizing the use of force, threat of force, or physical obstruction with X motivation. What constitutes trying to use that right? Almost certainly doing something that's First Amendment protected, okay? And it's kind of weird because there's sort of two First Amendment issues here, right? And it's a little confusing, right? The first is a First Amendment issue for intent within the statute, right? So this is within the statute. Like the statute itself requires it. That's this. That's this. So there's a First Amendment issue from the perspective of trying to understand the intent of the person, the perpetrator, the alleged perpetrator, right? And then there's the First Amendment issue, and this is a little fucky, of the law itself. And they're technically different things. So the first question is, under the law, have you made out an allegation under sub 2? And then number 2, is the law itself a violation of the First Amendment? Either facially or as applied. Is the law unconstitutional, which incorporates the First Amendment? There's that First Amendment issue, which has been pretty decisively resolved in favor of the law, facially. And then there's the law itself, which has a First Amendment component within it, at least for part of the violations. So now let's look at this Brock case. It's one of the earlier ones. It's a district court case, but and then we'll go to a more later appellate decision. But I think it gets you into the mode of thinking. Where is Brock? Oh, what is this? Okay. I think it gets you in the mode of thinking about the First Amendment issues at stake here and why this law is okay. And I actually do agree that it's okay. So this is a decision from the 90s. And you might imagine, right? Like, how could this be a First Amendment issue to have such a law? Well, the court's going to go through it in this Brock decision. The defendants, this is in the 90s, argue that face is constitutionally infirm because it is a content-based or viewpoint-based regulation of expressive activity, and it's vague and overbroad. Those are other First Amendment / due process concerns. They also argue they're entitled to a bill of particulars. That's kind of irrelevant. So here's the first question, right? We have I've gone over this before, how to look at a First Amendment issue. Is this even speech itself, right? A government regulation that limits communication because of the message it conveys is considered a content-based regulation and is subject to the strictest judicial scrutiny. The defendants argue that face is such a regulation. Initially, I must determine whether defendants' activity, as described, is protected by the First Amendment, right? Not whether or not they had the intent to interfere with the First Amendment. It's whether their conduct that is purporting to be prescribed by the law is itself protected. In other words, is what they did protected in this case? And that's another thing that you might think of with respect to Don Lemon specifically, is what he's doing protected by the First Amendment. The Supreme Court has rejected the view that an apparently limitless variety of conduct can be labeled speech whenever the person engaging in the conduct intends to express an idea. And this must make sense as like the starting absurdity for someone saying, well, drunk driving is my way of, it's my performance art. I'm trying to send a message by drunk driving on the road, and therefore it's protected by the First Amendment. That expressive conduct can't be that broad. And here's what the court says. As a result, the First Amendment does not protect the use of force or threats of force. Face, however, prohibits more than just force and threats of force. So there's a categorical rule. What's the categorical rule? That force and threats of force are not protected. Okay. So anything that's under 1 or 2, if it's force or threat of force, not protected. So we don't have to worry about it as much, I say, because there's a way in which it can be thought of as being relevant from a First Amendment perspective. But there's also this thing about physical obstruction. And well, what constitutes physical obstruction? And is it protected or always unprotected? But we resolved the first question, which is categorically the first two questions. Force, threats of force, not protected. Face prohibits more than just force and threats of force. It also prescribes certain nonviolent forms of physical obstruction. In fact, the information in this case is based on such physical obstruction. Thus, I must decide whether nonviolent physical obstruction, as practiced by the defendants in this case, can constitute protected activity. In deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, the Supreme Court has looked to whether an intent to convey a particularized message was present and whether the likelihood was great that the message would be understood, citing Texas v. Johnson. Who knows this case? Texas v. Johnson. We talked about it earlier in the year, if you recall. This is the case involving the flag burning. Okay, so flag burning is sometimes protected. Right? It's not categorically that every time you burn a flag, it will be protected. But that sometimes burning a flag, and even the American flag, can be protected. Both parts of this inquiry are informed by the context in which the conduct took place. With these principles in mind, the court has extended First Amendment protections to students wearing armbands to protest American military deployment in Vietnam. This is the Tinker case. Black persons sitting in at a public library to protest segregation. A protester wearing an army uniform during a skit protesting American involvement in Vietnam, right? And these are things that you wouldn't typically think of as like speech. What? Wearing a uniform is speech? Sitting in a place is speech? Protesters displaying picket signs and distributing leaflets outside a courthouse. Black persons boycotting white merchants. Individuals desecrating or burning flags. Demonstrators sleeping in parks. And an individual burning a cross in a black family's yard. Remember this case, RAV, because we need to deal with it later. At first glance, these cases seem to support the proposition the defendant's blockade of affiliated is similarly protected by the First Amendment. I do not doubt that the defendants, by blockading affiliated, intended to convey a particularized message. Moreover, it is likely that those viewing the blockade understood that message. The problem, however, is the vehicle for the message. When a message is conveyed through an activity that bears no necessary relationship to the freedom to distribute information or opinion, the government may prescribe the activity, notwithstanding the impact on the message. Thus, courts have generally held that messages delivered via physical obstruction, like messages delivered through the use of force, are not protected under the First Amendment. For example, you don't have a right to cordon off a street, and you don't have a right to block access to public and private buildings. That there are certain non-protected means of communication. And what one such means is obstruction. I agree with that. I think that makes sense. I don't like these we're going to protest the highways and it's part of my First Amendment to block a highway. In sum, the government and amici make a strong argument that under the relevant case law, the defendant's actions in blockading the clinic are simply not entitled to First Amendment protection. I did not hesitate to apply the categorical approach to use of force or threats, but he does hesitate to apply it to nonviolent physical obstruction. Ultimately, this apparent contradiction is a natural consequence of the court's historical treatment of a number of activities, including leafleting, picketing, civil rights demonstrations, and boycotts. Traditionally, those activities have been recognized as inextricably intertwined with the rights of speech and petition. So what's the concern? The concern is, how they define physical obstruction might not always be things that are just physically obstructing in the normal sense. Because look at how they define physical obstruction. Not just as things rendering impassable ingress or egress, that is to say physically, but also rendering passage unreasonably difficult or hazardous. So that doesn't seem to be just blocking it physically. Or at least it seems that there's ways in which you could physically obstruct under the definition of the statute, which is not the same as barricading or cordoning off a place. Back to Brock. Given these concerns and the defendant's arguments that FACE is facially invalid, I will proceed to consider whether FACE's physical obstruction provision is content neutral, and if not, whether it is necessary to serve a compelling state interest and narrowly tailored. So here's the question. Is this a content neutral restriction? In enforcing the First Amendment, courts have been concerned first and foremost with regulations that target speech or expressive activity on the basis of its content. Content-based restrictions are presumptively invalid and can only be saved with strict scrutiny. The analytical difficulty lies in determining which regulations are content-based and which are content-neutral. Where speech and non-speech elements are combined in the same course of conduct, the standard for neutrality has been articulated in at least two ways. It's a little confusing. At times, content neutrality determination has turned on whether the governmental interest in enacting the statute is unrelated to the suppression of free expression. At other times, and I have talked about why I find this to be analytically not satisfying, and I can repeat it again if you want. At other times, the inquiry has focused on whether the regulation is justified without reference to the content of the regulated speech. Regardless of the articulation of the standard, it is clear that our concern is with government motivation. Judicial scrutiny of that motivation varies, comparing O'Brien, and this O'Brien case is the draft card case. These cases do not necessarily make the objective tests recited above any clearer, but they do demonstrate that governmental motivation can be inferred from a number of factors, including the nature of the interest, blah, blah, blah. In support of the physical obstruction provisions of FACE, the government asserts compelling interest in ensuring access to reproductive health services, blah, blah, blah. FACE's prohibition of physical obstruction addresses these concerns directly by protecting ingress to and egress from clinics. FACE ensures that access to reproductive health services is not further eroded. By providing for federal, criminal, and civil remedies, they ensure that this access is not dependent upon the vagaries of local police, prosecutors, and courts. Moreover, the possibility of impermissible motive in this case appears remote. Congress's interest in access is a compelling one. Face addresses that interest directly and narrowly, and face leaves open alternative channels for communication of any message it might prescribe. Finally, Face's saving clause provides further evidence that Congress was aiming at conduct, not expressive activity. Despite this extensive evidence of a government interest unrelated to free expression, the defendants argue the government in enacting Face was actually targeting expression. In support of this argument, they argue that its intent requirement makes Face a content-based restriction. In support of their claim that it's content-based, the defendant offers the following reason. First, Face prescribes only that physical obstruction that is motivated by an intent to prevent people from or punish people for providing or obtaining reproductive health services. Second, Face does not prescribe physical obstruction motivations by other concerns. As a result, the argument goes, whether Face applies or not depends on the content or subject matter of the obstructor's message. The defendant's attack on Face intent requirement can be divided into three parts. Initially, the defendants argue that the intent requirement makes Face content-based on its face. Generally, however, a motive requirement will not in and of itself make a regulation related to the suppression of free expression. State and federal anti-discrimination and civil rights laws do not violate the First Amendment simply because they prescribe only those acts taken with a certain motive. The defendants argue, however, that their behavior is more analogous to sit-ins or picketing, and thus the case law on civil rights laws and anti-discrimination laws simply is not relevant. Even if the analogy were a good one, the Supreme Court's jurisprudence on picketing simply does not support this argument. Just as the government may prescribe employment decisions, membership decisions, and threats only when they are made with a certain intent, it may also prescribe picketing only when it is performed with a certain intent. The court has consistently upheld the state's right to regulate and even prescribe picketing in furtherance of unlawful objectives. To the extent that Face prescribes picketing, it prescribes only picketing in furtherance of unlawful objectives, picketing for the purpose of blocking access to a reproductive health service. Second, the defendants argue that even if Face's intent requirement does not make it content-based on its face, it provides evidence of illegitimate congressional motive. Blah, blah, blah. Actually, let me read this. In that case, so they cite this case, Police Department of Chicago versus Mosley. In that case, the Supreme Court considered a City of Chicago ordinance that limited picketing and demonstrating near school grounds, but explicitly exempted the peaceful picketing of any school involved in a labor dispute. In invalidating the ordinance, the court focused on Chicago's wholesale exclusion of picketing on all but one preferred subject, and the resultant poor fit between the statute's provision and the city's professed interest. In doing so, the court implicitly called into question the sincerity of the city's proffered interest. Similarly, the defendants argue Congress in Face has betrayed its interest in suppressing messages on one disfavored subject, reproductive health services, by implicitly exempting all other messages. There are at least three reasons why this argument is not persuasive. First, the ordinance in Mosley explicitly excluded labor picketing from its scope. There is no such explicit exclusion in Face. Second, Face, unlike the Chicago ordinance, is targeted at obstruction, not picketing. Third, unlike the ordinance in Mosley, there is an excellent fit between the means employed in Face and the government interest at stake. Given these distinctions, Face's labor exemption, unlike the exemption in Mosley, provides me with very little reason to doubt Congress's stated motives. And then there's this final case law that I want to get to, which is the defendants argue that Face's intent requirement makes it invalid even if it only reaches conduct that is fully prescribable. In RAV versus City of St. Paul, the Supreme Court announced a new general rule. Although governmental entities may proscribe entire categories of speech, such as fighting words, it may be impermissible for them to selectively proscribe within those categories along content-based lines. In announcing this rule, the court also explicitly abandoned its categorical approach to fighting words. It applied this new rule to invalidate a cross-burning prosecution under a bias motivation crime ordinance, which, pursuant to a state Supreme Court interpretation, prescribed only those fighting words that arouse anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. In the instant case, the defendants argue, although Congress could, consistent with the First Amendment, have prescribed all force, threats, and obstruction, RAV precludes it from prescribing only those with respect to reproductive health services. This argument assumes, however, that the court in RAV abandoned all categorical distinctions in the First Amendment. It did not. By creating an exception to the general rule for regulations directed at conduct rather than speech, the court directly retained a categorical distinction between regulations directed at conduct and regulations directed at speech. In later cases, this distinction has been reaffirmed, and the conduct category has been expanded to include potentially expressive activities that inflict greater individual and societal harm. As a result, at this point, my analysis comes first circle. All right, so what are we getting at here with this interpretation? So says the court in Brock, and by the way, the other circuit courts say similar things. This law is okay because One, part of what it's targeting is not protected by the First Amendment at all. Physical obstruction, to the extent that it raises a First Amendment issue, it doesn't do so facially. And it does so in a limited way that's narrowly tailored. That obstruction by itself is not protected, and any of these other kind of activities either wouldn't be included or would only be narrowly regulated. And then, because this is regulating conduct and not speech, they're allowed to preference certain interests, religious services, reproductive health services. Even though they could get it all, they're allowed to do a subset of the problem. That's the First Amendment analysis. So if you were trying to raise a First Amendment objection to the invocation of this law in this case, you're probably not going to want to invoke it on a facial ground. You're probably going to want to invoke it with respect to as applied. Maybe, for example, Don Lemon could raise some freedom of press thing that you can't apply this as to me when A, I don't have the intent to intimidate or interfere with anyone's religious freedoms. Don Lemon might say, hey, I'm just following these people around. I'm not trying to help their shit. Think about what someone might say if they were charged for obstruction on January 6th. Well, if you were actually a reporter that was in the Capitol on January 6th, if you were actually a reporter there, and you didn't want to obstruct the official proceeding, maybe they could get you with being in a restricted area. Not clear they could get you with obstruction. And the constitutional issue as well, additional concerns to prescribe this in a way that it would limit journalists' rights, So I don't think it's like a very strong as applied challenge. I would sooner just raise an issue within the statute itself, assuming it's constitutional. So let's get to the actual application. The big things that I'm going to want to see if I think a charge should go through is A, you're going to have to show me evidence of one of these three things: force, threat of force, or physical obstruction. On current evidence, I'm not sure. I haven't seen anything to suggest that they were making ingress or egress impassable. If someone could show that they're blocking entrances or stopping exits, maybe you could make out this first part. But I don't think this first part applies. So I think we're going to have to focus for physical obstruction on the last part. The last part is rendering passage to or from a facility or place of religious worship unreasonably difficult or hazardous. And I'm not sure that there's evidence of that either. How did they render passage hazardous or unreasonably difficult? Did they stop people from leaving? Did they shout threatening words? They definitely disrupted. But does mere disruption mean you render passage to or from a facility unreasonably difficult or hazardous? I don't think so. So I'd want to see more. How are they specifically stopping people from passing to and from the facility? Or how are they rendering impassable ingress or egress? So that's the first issue, which is finding evidence of the actus reus. I haven't seen force. I haven't seen threats of force. And I haven't yet been convinced that there's sufficient here for physical obstruction. Maybe this last one is the closest. But I don't know how rendering a service unreasonable to actually run, right, is the same as rendering passage unreasonably difficult or hazardous. Obstruction means coming in with cameras and stopping the service. Right? So, Wando, you have to chill, right? Chill. We're looking at the definition of physical obstruction that the statute provides. The statute has provided us a definition. It's not this one. So you can just read it, right? You're actually just allowed to read. You actually have the ability to just read. Physical obstruction means rendering impassable ingress or egress from a facility that provides religious worship, right? Place of religious worship. I'm not sure that any video I've seen shows this. That they've rendered impassable ingress or egress to the church. Maybe it happened. If it did, I haven't seen it. There's another way to physically obstruct, which is rendering passage to or from such a facility or place of religious worship unreasonably difficult or hazardous. And I haven't seen evidence of that. Maybe it exists, but I don't think just making a disruption that makes the service itself impossible necessarily makes passage to or from the place of religious worship unreasonably difficult or hazardous. And I think you do need to show that. So that's the first big area of evidentiary issues for the face statute. The second big issue is one we've already previewed, is showing this intent. Did you intend to injure, intimidate, probably not, right? Intimidate, and let's see the definition of intimidate. To place in someone in reasonable apprehension of bodily harm. So no, right? Interfere, okay, maybe. Intentionally interfere with or attempt to, right? So, okay. Interfere, maybe. With any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom. So, did you attempt to interfere with their rights of religious worship? Unclear. Unclear whether the court will interpret that as a dual intent, not just the intent to interfere, but the intent to interfere on the First Amendment ground. And unclear if that's the standard they apply, whether or not the evidence will show it in this case. Because what they're going to say is, yeah, we intended to interfere, but not to interfere with their exercise of First Amendment religious freedoms. We did so to interfere with participation in ICE and his involvement in ICE. And again, if that triggers you, just think about the hypothetical. 5 people storm into a church and they say, the pastor's sleeping with the altar boys. Is that group of people, are they intending to interfere with the lawful exercise of First Amendment religious freedoms? I think most people would say no. Now, if they don't interpret it with this dual intent way, and I think there might actually be case law that it is dual intent. Let me just do a quick little. I thought I saw something. I don't know if the right term is dual intent either. It might be but you know what I mean? Not just the intent to interfere, but the intent to interfere with respect to the right. I hope that makes sense. I think you're just not understanding, Juan, right? So I'll write it out. I don't think you're understanding. there's the intent with respect to interference. And I would agree. That's made out. Okay? Yes, I agree with this. But then there's the intent based on the motive of 1A. Am I intending to interfere? You found it? We'll put it on 0. Okay, where is it? I'm waiting. Withers. This is a Breaking Points video.
If you're an illegal alien, this runway is your future because you're headed home.
We're joined now actually from the border, Colombian border with Venezuela.
All right, we'll watch this entire thing. There's the intent with respect to interference, and there's the intent with respect to the motive for the First Amendment. I'm not sure if both of these apply. And so I'll do a little digging on that further. But now you can start to understand why, for me, it's not a foregone conclusion that the FACE Act was violated. And in fact, I think it's a little ridiculous to think that Don Lemon has the evidence so far, at least from what I've seen. I don't think that's true. Okay. That's the analysis. So I think it's a no-go on Ku Klux Klan. That doesn't mean they won't try, by the way. I want to be clear. Everything I'm saying is I'm not sure if they will try. I'm not sure that they will try. They won't try. So they might try. But I don't think it follows the Ku Klux Klan. And on the FACE Act, I think there might be trouble. Again, not saying they won't try. On the physical obstruction, meeting that out, because I haven't seen evidence of force or threat of force. And then, depending on how they view intent, if it's only with respect to interference that incidentally implicates First Amendment rights, or whether or not you need to also show the motive with respect to First Amendment. So that's my neutral analysis. Okay? I hope that was helpful, and it was a little bit more sober than some of the charge them right now Curtis Yarvins of the world.
We're joined now actually from the border, Colombian border with Venezuela, by journalist Yoan Grillo, truly one of the very best out there. Please go subscribe to his Substack over at crashoutmedia.com. It is one of, I think, the most invaluable places to get reporting from Latin America. Yoan is based in Mexico. Yoan, thank you.
We have our Breaking Points queen, Crystal. And we have Emily here on the left, and this is the guy, and this is the source for Grant Withers.
So much for joining us.
Yeah, great to be here. Hope it was well there.
Now, you've been embedded actually with Colombian law enforcement as the chaos in Venezuela ensues. Can you just give us a sense of what people should absolutely, by the way, go over to your Substack and read your piece about this. We put D1 up on the screen. This is Yoan's reporting from the ground in Colombia. But if you could just give us a sense of what it's been like on the ground in Colombia, where Donald Trump has threatened Gustavo Petro since this Venezuela operation was completed. What's going on down there right now?
Yeah, sure. So I'm in Cucuta, which is the biggest border city between Colombia and Venezuela, and one of the biggest communities of Venezuelans outside of the country. And you've got the situation around the border post with a lot of Venezuelans who come over to work and a lot of refugees as well in neighborhoods here, but also one with the military outside of the city. Now, one of the things that happened is that immediately when the attack happened on Saturday at 2 a.m. Venezuela time on Saturday, the colonel was saying he was woken up then. They had immediately had a meeting with President Petro and with the Ministry of Defense to say we have to react to this, and they sent 30,000 troops to the border. Now, part of this was just because of the threat, or what they saw as a threat of any US aggression that could spill over. The same as if in the United States you had suddenly an attack from China on Canada. I'm sure the US would immediately send troops to the Canadian border just as a kind of response. But also there's a guerrilla group called the ELN, the Ejército Nacional de Liberación, National Liberation Army, which is a guerrilla group also cited in the indictments against Maduro, which crosses both sides of the border. It's about 5,000 people. And immediately following the attacks, they noted a lot of these guerrillas moving right over back into Colombia, responding. But since then, the guerrilla group has now issued a statement saying, we need to respond to gringo aggression. So you see these things, and the army were looking at this. Also, you had in December this to Gringo, responding. But immediately following the attacks, they noted a lot of these guerrillas moving right over the border. It's about 5,000, which is a guerrilla group also cited in the indictments against Maduro, which crosses both sides of the border. It's about 5,000 people. And immediately following the attacks, they noted a lot of these guerrillas moving right over back into Colombia, responding. But since then, the guerrilla group has now issued a statement saying, we need to respond to Gringo aggression. So you see these things, and the army were looking at this. Also, you had in December, the same guerrilla group carried out a wave of attacks and bombs and all these kind of things as well.
Can you talk a little bit more about that?
Yeah, so this is suggesting they straddle the line between Venezuela and Colombia doing shit. I don't think this is what you're trying to show, but I'm going to keep listening.
What is your sense of why they were moving into Colombia, what they may do going forward, and how significant they are to the future in Venezuela?
So I think that just immediate response. I mean, they move back and forth over the border, and so they're very present in both countries, and they can move very easily.
Okay.
And immediately when they saw the attacks, it was kind of an immediate retreating movement. They saw large people like, we're going to be attacked ourselves. Could their camps have been targeted? Were there CIA locations of some of their camps, and so they move into?
Okay, but then this is not having a humanitarian effect then, by your own view. How is this proving your point that it had an immediate humanitarian impact?
Colombian territory. But seeing that it was, a more...
And also, these are guerrillas, right? It's getting rid of the cartel presence there? But no, you're saying they're going back and forth.
Limited attack. I think one of the big situations happening right now, and there's this news this morning about this, there's apparently a bunch of kidnapping of a bunch of police officers by the guerrillas. And there's a lot of reports that are quite hard to confirm. But from Venezuela, since this U.S. Special Forces abduction or apprehension of Nicolas Maduro on Saturday, you've got a lot of these armed groups emerging and coming out more. So the guerrillas, the ELN, in a lot of this part of Venezuela, they move people, so they're very, very openly present there. And they're working with Venezuelan authorities. You also have this group called the Colectivos, which are basically pro-government or pro-Chavista, Chavista being the socialist ideology, named after Hugo Chavez, the founder. These are armed groups which are very, very present in the neighborhood, and we've seen them come out a lot more. So people are telling me that, like in the areas now, they're seeing these militias out. Just talking to a colleague in Caracas, Venezuelan colleague in Caracas, who's sending me information there. From there was a big march on Sunday following the apprehension of Maduro, where a lot of these colectivos came out openly holding guns, openly carrying Kalashnikovs. So I think there's a kind of worry about, with a certain vacuum of power, with the Venezuelan government being weakened from above by the United States, then from below, these kind of armed groups taking more power. And one of the things my colleague in Caracas was saying is there's a worry this could become a bit more of like a Lebanonization of the streets with these different armed groups, ELN.
Wait, these are Colombian far-left guerrilla insurgency groups.
Colectivos and different groups openly kind of controlling the neighborhoods if there's not a clear authority asserted.
Well, let's play here Donald Trump talking about Gustavo Petro. This is going to be D2.
Colombia is very sick too, run by a sick man who likes making cocaine and selling it to the United States. And he's not going to be doing it very long, let me tell you.
What does that mean? He's not going to be doing it very long.
He's not doing it very long. He has cocaine mills and cocaine factories. He's not going to be doing it very long.
So there will be an operation by the U.S. and
It sounds good to me.
And we can go ahead and put this next element up on the screen as well. This is Gustavo Petro a couple of times actually in recent days, basically saying, come get me. Not dissimilar entirely from what we saw from Nicolas Maduro, obviously before Trump came and got him. Yoan, just wanted to ask how this back and forth is affecting basically the reality on the ground in Colombia. That's kind of what we've been talking about the entire time. But how fragile is, or is not, how fragile is Petro right now? What is the sense on the ground?
So I think Petro is a very, very different thing from Maduro, and a very different situation. I mean, Maduro was indicted twice. Was indicted in 2020 and again this year on narco-terrorism conspiracy, cocaine trafficking. We don't know about any indictments of Gustavo Petro, if there's any there at all. The other thing is that whereas with Maduro, there's a pretty credible claims that Maduro stole the election in 2024, and though Trump hasn't really talked about this much, as being much the reasons, the political reasons, it's more about crime or oil. There's Marco Rubio emphasizes that, and he was Venezuela was quite a kind of rogue regime in some senses around the region. That's not true. There's no real serious claims that Gustavo Petro stole the election when he was elected, and he actually will leave power this year. Now, Gustavo Petro is very big on social media and talks, very kind of anti-imperialist talks, a very kind of hard rhetoric. But it's quite hard to see if that would be backed. With the military, I was with the military in Colombia, and my sense is the military in Colombia are actually quite right wing. They've fought for years against the FARC, the left wing, the FARC, and now fighting the ELN. I think they're quite anti-leftist, very different than the Venezuelan military, which is run by Chavistas. And
All right, this is New York Times. Colombia's president, Gustavo Petro, a stalwart leftist, has promised to achieve peace settlements with armed groups that have kept the country, that is the Colombian country, in a near constant state of conflict for more than half a century, right? Because this group, the ELN, is aligned with Maduro. But now Mr. Petro is threatening military action alongside Venezuela against the largest of these groups, the National Liberation Army, or ELN, a one-time revolutionary guerrilla group that experts say has become a major cocaine trafficker with a deep foothold in Venezuela. If the ELN does not join the peace process by leaving Venezuela, there will be joint military action with Venezuela, Mr. Petro wrote on X. Oh, so wait, so there, let's see, hang on. With the government of Maduro? But weren't these guys aligned with Maduro? Interesting. Let me keep reading. Venezuela's interim government did not respond to requests for a comment on Mr. Petro's message, but his warning reflects the pressure facing Latin American leaders as President Trump demands that the region's countries from Colombia to Mexico target groups the United States has designated as terrorist organizations or risk unilateral U.S. action. The fear that Mr. Trump is serious grew significantly this month after the U.S. raided Venezuela and captured Nicolas Maduro. The Trump administration has declared that the United States as in an armed conflict with a confidential list of 24 drug cartels and criminal groups it has designated as terrorists. There is no evidence that the groups are engaged in such a conflict. The ELN is on that list, which the New York Times obtained. The ELN's top commander, Elisir Erlinato Chamorro Acosta, who used the nom de guerre Antonio Garcia in response to questions from the Times, asserted that U.S. prosecutors will not find evidence because there is none and does not exist. We are not and will not be drug traffickers. He also denied the group was present in Venezuela. The ELN formed in Colombia as a Catholic Marxist group in the 1960s, but experts say that by the 1990s it had turned to cocaine trafficking, like the more powerful Revolutionary Armed Forces of Colombia, or FARC. Then Colombian U.S.-backed military descended on the groups and the FARC splintered. Experts say the ELN took refuge in Venezuela and expanded there, growing wealthier through drug trafficking, tripling in size to around 6,000 fighters, and forging links with corrupt Venezuelan officials. Colombian authorities have said that the armed group served as a useful shield for the Maduro government against domestic and foreign threats. As the U.S. military buildup began in the Caribbean, Venezuelan officials relied on the ELN to protect the border with Colombia, which they worried could be a backdoor for U.S. military operations. And the ELN vowed to respond to any American intervention. I see. So they were aligned. The message from Caracas over the recent months have been, you lock down the border, that's your job. With Mr. Maduro gone, and Venezuela's interim government leaning towards rapprochement with Washington, the future of that alliance is uncertain. Mr. Garcia of the ELN acknowledged contact with the Maduro government, but said it was in the context of its peace negotiations with Colombia. Colombia and Venezuela's escalating crackdown on drug traffickers appeared focused on Catatumbo, a mountainous border region that the ELN has fought to control. Venezuela's Interior Minister Diosdado Cabello, in a news conference this week, touted recent anti-narcotics operations, including in the Venezuelan side of Catatumbo. He called them a serious blow to the cocaine industry and the narrative that Venezuela is a country that facilitates the traffic of drugs. He did not name the ELN. Asked by a reporter which cartels were involved, he deflected. It says it depends. What we do know is they're coming from Colombia. Mr. Cabello's assertions came as he stands accused in the federal indictment against Mr. Maduro of being enriched by drug profits and of partnering with the ELN and other groups. The day after Mr. Maduro's capture, President Trump accused Mr. Petro of also being involved in the drug trade and suggested action against Colombia was possible. A hastily arranged phone call between the two presidents eased tensions, but only increased the pressure on Mr. Petro. In recent days, the Colombian president repeatedly trotted out data on his government's drug seizures and its success in curbing the cultivation of coca, the base product for cocaine, which nonetheless remains at record levels amid soaring global demand. He also turned his sights on the ELN. Peace talks between the government and the group were suspended last year after particularly deadly clashes. An episode, there was one that left 80 dead and 50,000 displaced. This week, the ELN proposed a nationwide agreement with the government and offered Mr. Petro rebuffed. An agreement was offered, and the ELN destroyed it with blood and fire. He called instead for ELN fighters in Venezuela to disarm, return to Colombia, and begin a process to cede territory and reintegrate into society or face military action. After Mr. Maduro's capture, Mr. Petro also announced the deployment of 30,000 troops to his country's border with Venezuela. Experts say Mr. Petro's resolve to either dismantle or crush the ELN is a reflection both of Mr. Trump's demands and of domestic frustration over his past handling of armed groups. Mr. Petro, Colombia's first leftist president, entered office in 2022, criticizing its military-focused strategy against the groups as ineffective. He promised total peace with the groups. During talks, the military paused offensive operations, but analysts and government officials say groups like the ELN took advantage to expand their territory in Colombia, plant more coca crops, and consolidate trafficking routes. Ms. Dickinson, the analyst for the crisis group, said the failure of the government's peace policy came as a disappointment to Mr. Petro and the government. They really believed that they could sit these armed groups down and make a deal. The lack of any breakthrough shifted Mr. Petro toward a hard-handed approach. Mr. Petro's original approach also eroded trust with Colombia's security forces. A patchwork of ceasefires left them without any clear rules of engagement. It's difficult for police and soldiers to know exactly who they're supposed to be combating these groups. Colombia has one of the region's largest militaries with 269,000 active personnel, second only to Brazil. But it's aging and costly to maintain. Mr. Petro, in the interview with The Times, also expressed concern over the military's lack of newer technologies. The ELN commander, Mr. Garcia, said his organization engineers and technicians had built drones and anti-drone systems. Analysts say the group is, in fact, known to have such armaments. Mr. Trump has suggested the U.S. wants to carry out land strikes against designated cartels, and the U.S. administration is pressuring Mexico to allow U.S. military forces to conduct joint operations. It's unclear if there's similar plans. Ms. Dickinson said any strike against the ELN could cause civilian casualties and do little to dismantle the group. The ELN is not like a conventional force. They work in plain clothes. They operate within cities and towns. You can't blow up the ELN. It doesn't work. I don't think this supports your position. The fact that this group from Colombia, who is in Venezuela, and again, I'm not so sure that this has had any humanitarian impact to benefit the people of Venezuela. What's the proof of that? And they seem like a small group. All right. I mean, this is evidence that people who are accused of drug trafficking crossed the border, but it's a little different than you painted it, which is that like the Venezuelan drug cartels are moving across and they've left and all that shit, but where it seems like this is part of a longer intractable conflict between a Colombian group that was in Venezuela and where it's like an irregular sort of operation. It doesn't seem as clear cut as you presented it. Like, oh, this has produced humanitarian results. And my question is like why do we think that? And if it's just offloading to more trouble in Colombia, I'm not sure that that's gonna. It seems like the problem with humanitarian issue in Venezuela has to do with the government. But maybe I'm stupid. But you called this a wellspring of humanitarian results has already occurred because of many cartel members leaving and fleeing Venezuela. That's how you characterized it. So no, but kudos to you having a source. This is true. That they appear to have either crossed the border or they regularly crossed the border or they acted in response to the action. But I'm just not sure that that's humanitarian. But kudos to you. Okay. You want to see more? Yeah, but I just don't understand, like, do you consider this a humanitarian result that has resulted in humanitarian outcomes? This movement by the ELN? It feels a little bit more like equivocal and uncertain. But kudos to you. Have a source. It's a start, man. I don't know. Like, it also could go. Is there a reason to think it'll go well over the status quo? Maybe if Venezuela is seeking rapprochement with Washington, it might lead to curbing them potentially. But again, I don't see that as addressing the major reasons why I'm against this action. Humanitarian in the sense of entrenching the Chavistas, to me, doesn't seem that good. If we're just making the Chavista regime stronger, it seems like maybe geostrategically it's better for America, if something, right? Doesn't seem like a benefit for the Venezuelan people to uphold and work with the same people who tortured and stole their elections. What, so we can get some like guerrilla groups who are Colombian? I'm not saying the Venezuelan people aren't good people. Okay, last stuff. Last things. Very girthy, very very substance-filled stream today. There was one other thing I wanted to do. The threat of the car already in motion. Oh no, that's the Laid Back Law channel. Where is it? Where the fuck is it? Oh. Oh, I can't do it today. I'll just do this. I'll just do this and then we'll call it. I'm feeling better, by the way, but still a little bit shaky. A retrospective. We're now a year into Trump's second term in office. And my God, I think that this is potentially one of the worst years in our recent history, just in terms of the staggering amounts of corruption, the inactivity and lethargy of Congress. Like, what the fuck have they done? The incompetence and criminality of the administration. So it's worth thinking about right now. The road ahead. I'm actually very optimistic about the nature of the political situation. As blackpilling as some events might be, you look at the polling and enthusiasm is highly up among Democrats and down among Republicans. We're winning on the generic ballots as well as these individual races. But I'm worried that we're not making all the gains that we could be. And I'm worried that we're not prepping ourselves for when Democrats take power. I do think that so much of what the Democrats are going to have to do is clean up Trump's mess. And there's a kind of like incentive structure that's a little odd for Democrats currently in the following like shutdown fight. In that, passing any kind of meaningful healthcare reform or these ACA credits is a bit of a bailout to the administration, but it is something that the Democrats have messaged on. It's unclear whether or not the Republican Party is willing to budge on any of these negotiations. And I'm not confident in the leadership of the Democratic Party at this time. I did see a little bit of the majority report today. I don't know if it was today or... yeah, it was today, actually. It might have been a clip from before or something. And I'll just note that there was a moment where Chuck Schumer is like kind of downplaying Biden's accomplishment with the Chips and Science Act after Trump is trying to like take credit with it with Lutnick. And that really made me sick to my stomach to watch it. And I know it's like, who the fuck cares? It's not any one moment. It's just this feeling of like possibility where I think that there's a great deal of potential for us to take advantage of a shitty situation that people are recognizing and seeing that it's not going the way that a lot of people were promised. Even some Trump supporters on their own terms think they haven't drained the swamp. They're focusing too much on international issues. And so their engagement is lower. And I'm just worried. Maybe I shouldn't be. Maybe this will all be put to bed. But I think that there's great opportunity. I'm hopeful. I don't want us to fuck it up, and I don't want to snatch defeat from the jaws of victory. That's all I'm saying. Because this year has been horrible. Horrible for Trump, horrible for the country, horrible for the rule of law. Just as bad as I thought it would be, maybe worse. And even the people who are like, I don't know, maybe he'll do whatever. Anna Kasparian, etc. They're starting to see. And I hope it's not too late. Should Dems focus on Palestine? No, I don't think so. Anyway, that's all I got for you right now. It's exactly what he's going to do. You guys talking about vaccines? I think that's all I have for now. I have another stream planned tomorrow. Oh, I'm telling you right now, I'm going to be collabing with, well, I don't know if I'm going to announce it right now. Collab this weekend on Sunday. I'll announce it when I have final confirmation, but I think we're locked in. I'll talk to Non-Fun at some point. I also want to do this kind of like a signal boost of other like lib streamers at some point. So I'll have to like put a tweet out or something. What else? Nothing. You guys are the best. Oh, I might react to some Rob Noor content and to the cope from Ryan Mullally at some point. I still want to review the Jack Smith stuff. There's that Destiny conversation with Enrico Tario. Yeah, maybe I'll invite Avi to come through. That'd be fun. We invited him to do the Drew Pavlo thing, but that was like very last minute. So understandably, he didn't. It was too late to have him in. When are you having Hassan on? I would get so much shit if I had Hassan on, or he would have me on. I'm an ant. Oh yeah, you like that? All right, folks. I love you all very much. Stay so cool. I'm getting better. I'm using this like steam thing. It's like a steam mask to inhale steam. So that'll be fun. That'll be great, wonderful. But yeah, stay cool. We'll talk soon. Collabs coming up with some left-wing people, some right-wing people. And I want to talk to Connor too, because that motherfucker. Oh, this is my fucking call out to Connor. Hey, Connor, if you can't, and I'll talk to him about this. Connor, if you can't like properly represent what I'm telling you because you don't listen, don't go lie about what I say or get it wrong and like tell it to Destiny in front of 10,000 people. Someone instantly pinged me when that happened. And you said I said like the direct opposite of what I've been saying because you can't fucking listen. It pisses me off. I didn't represent that officer created jeopardy doctrine is the law of the land. Literally the opposite. Every time I bring that up, I say the Supreme Court hasn't decided in Barnes v. Felix. It's so annoying. Like, why do I even caveat what I say if you're not going to listen to it? And then you go like, oh, he's crazy. He thinks he's just arguing the law as he would like it to be. Literal opposite. Because you don't fucking listen. Because you're just waiting for your turn to talk and monologue about your history bullshit. So do me a favor and why don't you clear before you're going to represent what I say? Because I actually take some time to like think about it. You have shown like you're incapable of representing it multiple times. That's my call out. But Connor, love to talk to you. We should chat. And maybe I'll reach out to you tomorrow morning. Stay cool.